Well, good morning, everyone. So, hi, my name is Jay Thomas from the Georgetown Law Faculty. It's good to see so many old friends here in the audience today. Thanks for your patience. We're a little bit later this year. We wanted to do a two-day event, and finding space at Georgetown is a bit of a struggle. But I thank you for holding on this long, and with the support and assistance of the Berkeley Center for Law and Technology, we've been doing this now for 8 years. So for me, it's a big part of my annual routine. Thanks again for coming. So we'll talk more about this tomorrow, but we have been doing a lot in the area of law and technology here at Georgetown. We have our new Institute for Law and Technology. We're a little behind some of our peer institutions in establishing that, but we finally got around to it. We've hired Alex Givens, who's sitting here from Senator Leahy's staff, to come join us. We have our new Georgetown, it's a little tricky title. Who came up with this? It's the Georgetown Law Technology Review. Something like a missing "and" in there or something. It's the Georgetown Law Technology Review. So we have a new online journal. My favorite part of it is the so-called tech explainers, where we get people just to sort of lay out fundamental technologies that have become part of cases and part of public discourse. We still have our Iron Tech Lawyer competition, in which we invite teams of our students to code apps, and then we have a big contest about who's got the best app. And we started to put out a course, Coding for Lawyers, in which we had, I think, 22 spots, and we had about 150 people sign up for it. So I think we might start teaching coding to lawyers to everyone coming in, at least everyone who's interested. We have that capacity. So the things have been changing very quickly. But the conference here, I think, hopefully is a perennial event, and we thank our sponsors, Cisco, Samsung, Google, Verizon, and Intel. As I often say, law schools are only as strong as their friends. Without your assistance, we wouldn't be able to have the kind of interaction that we're having today. So I look forward to our event. We're especially pleased to have Judge Gilstrap and Judge Robinson come to join us today, and as well, a third member of the federal bench is here with us, Chief Judge Sharon Prost. I think everyone, except for a handful of my students, probably know the Chief very well. Prior to going to the bench, she was the Chief Judge of the Committee of the Judiciary for the U.S. Senate. She's written many notable patent cases, some of which we've talked about in my patents class, like Bosch v. Pylon, Apple v. Samsung, you might have heard of, I4I v. Microsoft. My favorite still was the earlier case in cruciferous sprout litigation, which has this memorable caption you can just never forget. I don't remember what the case held, but it's a good name to remember. It's been quite a bit of change, I think, at the federal circuit right now. So it's good to have someone who's been a pretty steady helm. Obviously, the number of PTAB appeals is coming up to the federal circuit and really changing the jurisdictional composition of the court. There's been a lot of changes of personnel. So you've had to reside in a relatively brief period of Chief Judge with really a lot of changes. As someone who also clerked for the Chief Judge of the federal circuit a long time ago in that same chambers, I remember when she came Chief Judge, all of a sudden the General Services Administration showed up, and then there were budgeting concerns and all of that. Another constant, though, is you do enjoy, I think, the best vista, the most fabulous office view in all of Washington, D.C., right over the mall and the White House, which we've learned recently will be more occupied than we thought that it would be just a few days ago. So I think that's all for the good. Anyway, it's my pleasure to invite Chief Judge Prost to address us.
Well, I'm going to keep it pretty informal in this group. I'm delighted to be here this morning. I know you have a full program today and tomorrow, and maybe my brief remarks can kind of set the stage. And if Professor Thomas tells me we have time, I'm more than happy to entertain questions. But I'm particularly pleased to be at Georgetown because I'm starting a fifth career at Georgetown in January. I'll be teaching a course as an adjunct professor along with my former colleague, Judge Gallarza. So I'm kind of excited about that. As Professor Thomas said, initially I was going to dub my talk Change, but with everything else going on in Washington and around the country these days, that seemed a little too loaded to describe what's really happening in our patent system, which is much less glamorous, I have to admit, and much less grandiose than the other change that's going on in the city. But nonetheless, I think that most of you in this room appreciate how our patent system has been transformed by recent events in the last decade. it's easiest for me to use 15 years as a benchmark because that was when I came to our court. And I came to the Federal Circuit as a non-patent person, and the Federal Circuit was celebrating its 20th anniversary. And I figured, I can do this. This can't be that hard. I get my case, and then I look at the case law. We've got 20 years worth of case opinions that we've issued, and I applied a law to the facts. I heard a laugh there. That was true. I certainly learned that there were major gaps in terms of answering many of the questions that arise in cases in patent law. And I guess I hate to admit, but 15 years later, I can't really claim much success in having filled that gap and added to the clarity. Now, we in Washington know how to do certain things very well. And rather than admit failure, our answer to failure is one of two things. Either we point to somebody else as being responsible for that failure, and if I can find East, I can point to that building on Capitol Hill, or we pretend our failure was a success. And I can kind of do that too. We've tried to do our best. Our court was created to have specialized jurisdiction, and the impetus for that was because we were supposed to add uniformity and predictability to a fractured patent system around the courts. So that's what we see our mission as being. It's not surprising that our bosses at the Supreme Court see things a bit differently, particularly when they're dealing with an area of law that is really so wonderful because it's chasing the science and the technology and evolving constantly. So it's not surprising to me personally, having been in this business now for 15 years, that there's a tension between trying to create firm rules that apply across the board and the fact that everything is changing beneath us, and the law has to try to stay current and change as the cases change. So that's an inevitable tension, and I'll call it a success for now. But there are some broad contrasts that I can draw between then and now. One, as you all know, is the face of the court. Since I came to the court, it's turned over by 8 judges. 8 out of 12, we have 12 active judges. In the past 6 years, 7 judges have changed. So we really do have a new face. And it's a little different than it was. When I came to the court, I was 50. And I earned a well-deserved title as being sort of young, because on Capitol Hill, when you're 50, you're a pretty old person. But I was much younger than many of my colleagues. Now we've got 4 judges that are under 50. And so the face of the court is much more diverse than it's ever been. And it's actually acquired expertise that it really didn't have before. We've got 2 well-known trade lawyers, former international trade lawyers, Judge Reyna and Judge Wallach. And we've got a number of people who are so steeped their entire careers in doing patent law in different directions. 1, Judge Stoll in private practice, and 2, Judge Chen is the solicitor of the Patent Office. My own experience, as I said, was quite different because I came really not knowing patent law. And my evolution at the Federal Circuit kind of can be summarized but with you don't know what you don't know. Because everybody thought I'd really struggle. My first year was kind of pretty easy because I didn't know what I didn't know. It got harder rather than easier in years 2 and 3. And by the time I felt like I should have had the grasp of what's going on, I was much comforted by my very brilliant colleagues who would often comment to me 5 years down the road, the cases are just getting harder. And they were, and they are. The technology is more complex. The advocacy, frankly, I'll give you guys credit, is better. And therefore, the lawyers make it harder to do our job because they come up with better and stronger arguments. So the job keeps getting harder at the Federal Circuit. Second point I'd mention is our docket, because our docket has changed dramatically since I came to the Federal Circuit. When I came in 2001, about 30% of our cases were patent cases, and a very small portion of those patent cases were PTO appeals. Mainly, they were district court cases. Now, currently, our docket is over 70% patent cases. And for the first time ever, the majority of those in recent months have been coming from the PTAB rather than the district courts. For some of us, that's not necessarily such a welcome development. We like to review district court cases. They're very interesting. I know you work very hard in doing them, but they involve questions of damages and all kinds of interesting issues. And the PTAB appeals tend to be about single issue cases. However, as you probably know, at least in the foreseeable future, the excitement or the interest as lawyers in PTAB appeals involve a lot of the administrative law issues that are presenting themselves. And I'm going back to work when I'm done here, because next week is not only court week for our court, but on Friday we have an en banc appeal of a case called In Re Aqua, which involves the authority and what the rules are of the game in terms of motions to amend during PTAB proceedings. The other kind of sad thing for us is there's been a sort of relative decrease in the number of other cases that we do. And some of you may not know, but we are a specialized court, but we have many, many areas from which we hear appeals that are other than patent cases. And I've consistently been impressed by my colleagues, because even those who came to the court steeped in a background in patent law have enthusiastically embraced the other work that we do. And I know Judge Robinson and Judge Gilstrap have both sat with our court, and often when visiting judges come, they're kind of surprised that we do something other than patent law. But what we do other than patent law, veterans cases, Court of Claims appeals, MSPB cases, Court of International Trade cases. So it's nice to remember that we're not exclusively a patent court. And frankly, a lot of colleagues at our court aren't really thrilled at the prospect that we're becoming more and more of a patent court. Excuse me, let me get a drink. And so we can all make predictions about where we're going in our system. A few things remain to be seen. Maybe our friends at the Patent Office can enlighten us. But we don't know if the number of PTAB appeals and also the number of 101 cases is going to hold steady or eventually see a decline. An expression that everybody uses, and I do as well, and I hate, is this thing called low-hanging fruit. There's a theory that this major increase in 101 cases and in PTAB appeals will eventually subside, because a lot of the claims are just out there and they're broad claims, and eventually we'll get rid of that low-hanging fruit and the system will go back a little to the way it was. I don't know if that's true or not. It remains to be seen. And the other thing that kind of will be interesting that we have not seen yet in the whole PTAB appeal process, we haven't seen the cases after the PTAB rules on the validity questions. There will probably be very interesting questions coming up in terms of estoppel once the cases go back to the district court. I'm very interested in seeing the statistics. In other words, what portion of cases that are resolved one way or another by the PTAB on the validity question are just going to end the case and take it out of the district court's docket, or whether a large percentage of those cases will still have issues that remain. So that's something that we try to predict in our court, me as chief in particular, how we see our docket growing over the next 5 years. So there are just a lot of questions that are unanswered. But on the substantive law area, beyond the changes at the AIA, we've seen a lot since I've been at the court, beginning with KSR, eBay, Akamai, Theracense, inequitable conduct. I mean, inequitable conduct used to be the be-all and end-all and the subject of all conferences. Since Theracense, you hear very little about it. But the two things I'd just like to raise briefly this morning are the 101 jurisprudence, which I'm sure you're all aware of, which has changed dramatically in recent years, and also an issue that has not received much attention, but one that I think has the potential to not be a game changer, but to have a significant effect, and that's the halo decision of the Supreme Court and the potential increase in the number of willfulness assertions in cases. And I think that's something that I'd be interested in talking to district court judges about in the next year or two, to see how their cases and how they handle their cases is impacted by the possibility of an increase of assertions of willfulness. But on the 101 area, I mean, there are two buckets in 101, as you know. One is kind of the bio end, the Mayo, the Myriad side, and the other is the Alice and the technology, the computer side. Probably at least 90% of the cases we see in 101 are in the tech side. On the other side, we've had Ariosa, as you know, and we've had an opinion recently in rapid litigation. But that's really a minor part of our 101 jurisprudence. The main place is in the tech side. And I think we're doing pretty well, we at the Federal Circuit. We tried to set up rules and to have definitions and to have defined terms, and that didn't work out so well for us. And it was hard to do because the issues are evolving and the claims are all different. So now, for better, for worse, not through our own control, we're left with deciding every claim in every case on its own. And we don't have a great definition of abstract idea, but what we do now have, after our court having decided about 20 cases in the area, is I think we have some pretty good data points that we've laid out there. I think if you're a lawyer and you want to advise your client, you can look at these cases. There might be some outliers there that don't fit the pattern, but essentially, I think as we decide cases one at a time, look at claims one at a time, you'll get a pretty good idea about what passes muster and what doesn't. And that's done with the help of district court judges who have really stepped up, and they've got motions to dismiss and summary judgment motions. They've got a much heavier lifting than we do in 101, as is true of everything. But I think they too are trying to come to grips with what it means to be an abstract idea under 101. And I think the data points are helpful. As I mentioned, the willfulness thing is kind of a sleeper issue. I don't hear people talking about it, and I'm here in my ivory tower of Washington, so maybe I'm just missing something. But I think it has the potential to really change the way litigation is done in the district courts. I don't know. I hear from district court judges that one of the most important things for them is to have an idea at the get-go what the value of this case is, because that's where the possibility lies to close the issues down and to settle the case. And willfulness, treble damages, is just another matter that can lend uncertainty to the bottom line of what is this case worth. It's also their job, not mine, their job much harder than mine, which is to grapple with how those issues are presented at trial, whether you want to bifurcate the willfulness arguments from the merits arguments of infringement. So I, for one, will be looking carefully and with great interest over the next year or two in terms of what's happening in the district courts with respect to willfulness claims. With respect to what's going to happen in the next year or two, I don't know. We're grappling, as I said, with a lot of PTAP questions. We have a lot of very challenging, interesting administrative law issues. The truth from where I stand is most of the arrows are pointing towards Alexandria and the Patent Office. That's where most of the cases are. That's where a lot of the action is. I don't know whether that's a permanent change or one that will come back or not. I have my own personal preferences, but I really don't know. And then we've also got the prospect, as we've had in recent years, of more legislation. We've got venue bills that are hanging around there. We've got 101 bills that I guess are poised to be introduced. So from where we stand, we're just kind of watchers, but I think once we get through the change and the excitement of this election and what's going on after that, I still trust that patent law will remain a very special, interesting, and exciting venue for us. And now I'll take questions if we've got time, if there are any, hopefully.
I'll try to set a good example by using the microphone. So, Chief, thanks a lot for coming here today. It must have been, it's been a while, but as someone who worked for many years on the Hill, and then all of a sudden is essentially sort of a client of the legislature in the sense that you have to submit yourself to an oversight hearing every year. You have to develop a budget with other courts, and you have to keep your ear to the ground about coming legislation and sort of think about its possible impact on the court. For example, suppose you had interlocutory views of every claim instruction, so how would that affect your docket? So those are pretty challenging things. How did that transition for you from sort of being on the Hill staff and sort of dealing with these issues, but all of a sudden sort of being on the other side of the podium?
Well, there are two kind of questions sort of embedded. One is the transition from working on the Hill to then working in the court, and the other is kind of the day-to-day budget issues. That was the transition from just being a regular judge to being a chief judge, where the important thing for me are our cases. When I became chief, Judge Lurie called me. He's a very kind, generous man. And he said, you know, Sharon, as chief, you only have to sit on 75% of the cases. To which my reaction was, no. I mean, I love my cases. That's my job. Running the budget and figuring out whether the heat is working is not what I worked all my life to achieve. So I continue to do my docket of cases, but for run of the run, the good and the bad part of the Federal Circuit, which makes it a little more challenging to be chief, is that we have a unique role in the judiciary in that we have our separate budget, and we're much more independent than every other court that comes under the administrative office. A lot of what we do comes under the administrative office, but we have a certain degree of independence, which is not shared by other courts in the country. That independence translates to more work for us because we're doing things on a small scale and we are really quite independent in our decision making. And we have 18 judges. And at the end of the day, I don't have any grandiose goals for having been chief other than I will feel like I succeeded if at the end of the day my colleagues are able to say she made our life easier. And she cleared the underbrush so that we could do our work, which is deciding cases. So that's what I work for every day.
Good morning, Chief Judge. Peter Manel from Berkeley. So I was really intrigued by your comment about how the Federal Circuit had tried to establish some clear boundaries on 101, but was rebuffed. And many of us who are following this area share the concern that the Supreme Court has kind of taken us on a path that is still very murky. And so it's true that in the last year, we've seen a lot more decisions, data points as you described them. But it does strike me that it will be hard to create the clarity that the practitioner world, the tech world would like, without some further involvement by either the Supreme Court or Congress. And I'm just curious as to, was there sort of a point at which the court realized the Supreme Court is not going to be giving us much more and we just need to sort of head off into the forest and try to clarify things? Or would there be, some desire to have the Supreme Court revisit some of these cases, as they did in the 1980s, in the early 80s? The Chakrabarty case and the Diamond v. Here case really did clarify a lot of the law.
Yeah, but the problem with that is in both of what you've said, either having the Congress do something or having the Supreme Court do more, it's kind of maybe wishful thinking that they're going to clarify it. I mean, if they were to take a case, even Ariosa, I know there are a lot of people anticipated that the Supreme Court would jump in and take the Ariosa case on review, and they didn't. I don't know. Maybe there was a reason for a sigh of relief then, because you don't know what you're going to get once they grant review. The same may be true of Congress. I mean, I spent a lot of my career in Congress. Maybe the people, I have no involvement with people who were purportedly drafting legislative proposals on 101. But I will tell you that a lot of my experience in Congress was unintended consequences and the lack of clarity with what you get, which leaves the courts years, decades, to struggle with the lack of clarity.
Yeah, although I feel like we're reliving this movie, even though I was too young to fully appreciate, because in the night you get the Benson case in 72, then you get Fluke, and then there are a few other cases in that time period, and then the Supreme Court in some ways gets us out of that forest. I mean, they did clarify the law. I think, in fact, it did, open things up in ways that perhaps was intended or not. The other thing that I'm really struck by, and it sort of captures perhaps changes in how Washington works, in the Benson case, and I don't know if people remember this, the last paragraph of the Benson case, the Supreme Court said, we have really no understanding of computer science, and we would really welcome Congress to come in because we're in a new technological age, and without a legislative message, we're going to struggle. And Congress never reacted. We never got that clarification. And I almost feel, the Benson paragraph needs to be reiterated by someone because it is very difficult. And as you described, there's this kind of, there are two different buckets. And on the software side, perhaps we can get to some resolution, but on the bioscience side, I don't feel we can without, I wish the Ariosa case was taken, but I still think we're going to be struggling to advise the patent office and the practitioner world.
I think that's true. I'll just make one little comment about the Ariosa rapid thing, because maybe it's a good thing, but maybe it's a bad thing that we don't have that many cases because our court hasn't had the opportunity to speak on it. But I was involved in the rapid litigation case where we found the claims patentable. And I think when you look at these cases, maybe I'm just too much in the weeds, but if you look at the claims, there are real lessons to be drawn. If you look at the broad claims in Ariosa and even in Mayo, and then you look at the claims which are patentable in rapid litigation, I think there are some lessons to be drawn from that handful of cases.
Well, I would agree, but when you think about what a company like Sequenom would have been seeing when they wrote their claims, it was a different era. And they could have written claims that you might have been able to uphold. And so it's almost like a property rights issue that, these property rights are formed in this sort of prehistoric period. And now, you can't go back and rewrite your claims. So it raises a lot of fundamental issues about how a patent, because they got the claims, they made investments, and now they're left without any recourse. But I'll leave it there. You don't have to say more, but I think
I might be last. Judge Rose, thank you. I agree with you about administrative issues being one of the key areas of interest for PTAB proceedings. And I'm wondering whether you have any concern about the non-reviewability of decisions on institution and how the PTAB might get some consistency, which is a big issue at the PTAB right now, if there's no review of those decisions on institution.
Well, I'm not going to speak to that substantively because, as you probably know, we've got plenty of cases pending. There are all sorts of questions that people might say were left open in quo, or at least we haven't definitively spoken on yet with respect to where the lines are drawn on reviewability. And I think in some of our cases and our dissents that have already issued, you see the chatter and the tension between different views. So I think in the longer term, possibly or probably some of, we have quite a number of issues to be decided with respect to reviewability. And some feel, at least in our court, I think that those were left open and subject to debate about what exactly Quoso was telling us about the scope of reviewability. So that's just something that is going to be litigated in the coming years. And issues of estoppel, interesting questions of estoppel, and motions to amend. So there's a lot of interesting stuff going on, at least in the near term, in terms of what the Patent Office is doing in our review. And they're doing a very fulsome job, and Michelle Lee, as director, has done a great job in trying to add clarity. I mean, their hands are tied. They look to the courts, they look to Congress, and they've got a lot coming at them. And when you look back at the AIA and the swiftness with which they had to issue regulations, implementing regulations, and just what's gone on since enactment, it's really quite remarkable in terms of the heavy lifting they've done in that regard.
Yeah, they've also been doing a good job to fix consistency too, but thank you for your answer.
Thank you.
Hi, I'm Bo Goodrick from Steptoe & Johnson. Question for you, because I know that there are some Georgetown law students here as well, or here. I am a recent graduate as well, and you are teaching a class starting next year. At the same time, you said it's a changing environment, and I was wondering if there's any tips or advice that you have for younger attorneys or students moving forward, or advice that you'd have for your students when you get them?
I haven't really thought of it. I mean, I don't have that much of through my clerks, I kind of know what the market is, although our clerks are so great, they're part of a fairly elite crowd, so they are recruited heavily. I think the market is probably getting tougher in patent law, but I don't know that for sure. I mean, with the 101 jurisprudence and also the PTAB, there's probably been a shift from skills and district court litigation to doing PTAB proceedings. So there's a shift going on. I don't know. I mean, I think patent law as a job is still much more of a robust field than many, many other areas of the law. And I also think it's just a great area of the law. I mean, it's exciting, it's interesting, it's changing. I don't know if my colleagues on other circuits feel this way, but I feel like my docket is much more interesting than many of those dockets that they see in the circuits. So I think I would encourage people. I mean, I think patent law is a wonderful area, but it is, I think it is shifting. I think the employment market may be shifting. Law firms are probably having to take a look at their resources and how they're allocated, given the major uptick in PTAB proceedings and the possible slight decline. I mean, I don't like to say decline in front of Judge Gilstrap because his caseload is probably the largest caseload ever, and I don't think it's gone down that much. But there probably is a shift going on in law firms in terms of how they allocate resources in the field of patent law.
Thank you.
So please join me in thanking Chief Judge Prost.
Thank you.
Well, good morning, everyone. We're going to jump right into our first panel while we get set up. So we have so much to cover. Chief Judge Prost has gotten us off to, I think, a great start. She previewed a lot of the issues we're going to be covering today. And I want to just give a little background about this conference, which I feel is unique among patent conferences around the country. When the conference was developed, it had a somewhat different mission than a lot of inside the Beltway events. A lot of things inside the Beltway are focused principally on legislation, and here the sponsors of this conference wanted to try to bring more of the hinterlands, what's happening out in the district courts, what's happening out in the technology sectors, into the Washington discussion. And for the 5 years that I've been involved, we've been able to draw on many of the top district judges to come here and to interact with the practitioners and to share what really happens in the patent system at the trench level, where these patents are being litigated, how case management is affecting these decisions. And this year in particular, I feel we have a fantastic window into this world, partly because we've got the benefit of tremendous amounts and carefully cultivated data. So we're going to get to see in microcosm sort of what that outside world is looking like, how it's evolving, and we're very fortunate to have with us the people who are really at the forefront. So I want to mention Brian Howard is going to be our first speaker. Brian's at Lex Machina. He's going to talk a little about Lex Machina's history, but Lex Machina has really solved a massive collective action problem for those of us in the real world who want to understand data. As you know, much of the data about the intellectual property system is within the PACER system. One would think that as public data, this would be easily available, but it's not. The district courts rely on the PACER system to fund aspects of their, and so it's been hard to kind of break down some of those barriers, but Lex Machina has, and they've assembled that data and created tools that allow us into that world, and Brian's going to share with us sort of how they do that, and that's going to be very useful, and it'll give us really, I think, a big picture view of the system. And then we have with us Scott Bullock, who is the acting Deputy Chief Administrative Law Judge at the PTAB. And as we'll talk about, the PTAB really is where a lot of the patent system has shifted. Over the last several years since the AIA, the United States has been on this remarkable experiment. We've tried to bring more technically trained people into doing the validity analysis. And so he's going to be able to talk about how that process is unfolding. And then on top of that, we have Suzanne Monk, who's at the Federal Trade Commission, which for about a decade, and I see Suzanne Michelle here, my former student, and really someone who, when she was at the FTC, kind of opened up this Pandora's, even before Suzanne, I guess, in the early 2000 period, we get studies being done of the patent system by the FTC, which has sort of a dual mandate where they care about both innovation and competition. And that has been carried forward through Suzanne's work on notice and remedies, and now with this patent assertion entity study that Suzanne Monk led. And so we'll get to hear about that. And then we're going to be able to turn to the people who are sort of in that world directly. The leading judges in our district court system. We have Judge Gilstrap, who's already been mentioned multiple times today, but he has about a quarter of all patent cases in the country on his docket. And then we've got Judge Robinson in the District of Delaware, who has, for a very long time, had a very large docket. And we also have Julie Holloway with us, who's one of the leading trial lawyers. She's at Latham and Watkins. I noticed that among her big victories in a recent case representing NVIDIA, she got a big verdict against one of our sponsors. So it just shows you how open we are here and how we are interested in bringing the best and the brightest. And just in terms of backgrounds, Brian was trained as both a computer scientist and a legal historian. And now he's what we call data scientist. And so I think that Suzanne she was a math major, undergraduate, worked in practice, and then has been doing this policy-related work. Scott, I think, brings what the PTAB is really about. He's an electrical engineer. He's been working in the patent office trenches, so he sort of brings a whole other set of skills than a typical district judge. And then we have, the two most experienced district judges. And then I'm also proud to say that Julie is not only a graduate of our law school, Berkeley Law, but she's a computer science, electrical engineer herself. And so I think what we're going to see in this panel is just how different institutions, different perspectives are creating the patent system that we have. So let me just jump right in and give you an overview of where we're going to go in the next hour and a half. Brian's going to tell us about patent litigation trends. Scott's going to talk about the PTAB. We're going to then get into how it affects the district courts, in particular the stay decision, which has become one of the important aspects of many patent litigations. Suzanne's going to share with us the highlights of the FTC study. I'm hoping we'll talk a little about patentable subject matter, something that Judge Prost brought up. And then if we have time, we'll talk a little about fee shifting. This is another way in which the patent system is evolving through case management. So I'm very excited to be jumping into all these areas. So let's start with Brian.
Terrific. Excuse me, I'm going to stand up here since I'm a little bit of a peripatetic speaker. So I wanted to go over a couple of things in this few minutes that I've got here, if that's okay. I'm going to start off really quickly with what legal analytics is and why that's different from traditional legal research. I'm going to keep this to 15 seconds because this is not about marketing here. But traditionally in legal research, you're asking the question, I have some authority, how does my situation compare to that? Is this different? And if so, why? And if not, why? And legal analytics is really more about looking at aggregate behavior across a large chunk of things. You're not looking at a specific case so much as all of the cases across a particular party or within a certain jurisdiction. So it's a really different process. And I just wanted to start out with that sort of in mind. The questions that you answer are really different. And again, I don't want to go into this in a lot of depth, but there are, the talk that I'm going to present this morning is very policy oriented. There's a lot in here that we can do in terms of litigation strategy that I'm not going to address. So, all right, that gets me onto the sort of main portion here. I want to talk about two things in particular. I want to look very briefly at the effects of the American Invents Act and some ways that counting cases can tell us what effect it's had. We hear a lot in terms of record filings and what's going on in the patent world. I think we can provide a little insight there. And then the second part, sort of the main focus, I want to look at asymmetry in patent litigation. And asymmetry is a word that I've chosen carefully. I'm not sure I can find a better one, but I want to look at the distribution of cases among districts and among judges. And then I want to use a lens that I call the volume class to sort of tear this apart a little bit more. I want to look at the difference in behavior between parties that file lots of cases and parties that file relatively few. So that's sort of where we're going here. So I think everybody's aware that over the last 15 years, there's been an incredible increase in patent litigation. And some variation of this chart will show up in a lot of places. I should note that 2016 at the end there is only through Q3, so that will probably go up. Don't be alarmed. But what you see here is that there's a fairly steady level of patent litigation through the early part of the 2000s. And then there's this spike that sort of happens, this massive jump. And I think a lot of what I want to get at today is sort of a variation on how to tell the story differently or how to understand it differently. So with that, let's talk about the effects of the AIA. Same chart here I've just added where the AIA happened. It became effective in September 2011. And although this chart is done by year, you can see that it kind of really happens in the middle of that massive increase. What did the AIA do, and why are we even having a discussion about this? One of the things that the AIA changed was the joinder rules. So prior to the AIA, typically in a patent case, one would sue multiple defendants in a single case. And the AIA's general effect is to make it difficult to do that. Now, typically you would file a separate case against each defendant. And as a result, this makes it really hard to compare counting cases from before the AIA, where one case might represent 5 defendants, versus after, where you have 5 separate cases. So in order to address that, the solution that I've come up with is to look at counting sort of the couple or the pair of a defendant in a case. So prior to the AIA, you have one plaintiff who sues 5 defendants. We'll call that 5 plaintiff-defendant pairs, 5 defendant case pairs. And after the AIA, you would have 5 separate cases. So again, you have 5 pairs. So this makes it easy to kind of count before and after. When you do that, when you count that way, this is what that chart looks like. You see that there's much less dramatic explosion in 2011, except for that one point right before the AIA took effect. And the increase kind of continues for about 2 years after the AIA took effect. So I think this is a really interesting way of sort of looking at this. Again, what I take away from this is that there was a lot of increase after the AIA. In the other chart, it's kind of hard to figure out whether that was happening or what. A lot of the increase happened between 2007 and 2014, which is, I think, really when things peaked. And there's this record filing spike right before the effective date. And we'll come back to filing spikes in a little bit, but I just wanted to sort of set the groundwork here for that. So that sort of wraps up the first point. And again, I'm sorry I'm moving fast, but I want to make sure that we have time to look at this. So in terms of asymmetry, I want to look at where the cases are filed, what judges there before, and then I want to jump into this notion of high volume plaintiffs or frequent filers. So this is patent cases filed in the last 2 years, or at least this year through September. And this is a very large chunk of that chart that's orange, 40% Eastern Texas. And that's more than all districts outside of the top 5 here combined. If you look at that over time, I think it's really interesting to see that Eastern Texas has really risen significantly since 2012, and that rise has often come at the expense of case filings in Delaware, I think. You can see that inflection point around 2013, where the Delaware chart, which is the gray line, starts to go down, and Eastern Texas, which is the orange, really picks off. And again, we'll come back to why that is in a second. But in terms of the concentration of cases in Eastern Texas, I wanted to look at some other areas of the law and see how that stacks up. So, for example, in securities, which one might expect to be very concentrated in New York, only 22% of those cases happen in SDNY. And so the 40% of patent cases that are in the leading patent district is really, I think, an outlier in terms of other areas of the law here. These are the top 3 districts for each area. So the top 3 antitrust, the top 3 copyright. So you just get a sense of the scale of the numbers. In terms of who handles these cases. My co-panelist up here, it does indeed have more than 25% of the cases that were filed in the last 7 quarters, and that's a large chunk. It's more than many districts would have in other practice areas. So that's one way in which I think the distribution of cases is really asymmetrical. And to provide a little more clarity in that, I want to introduce a new notion. So I don't mean any disrespect to the excellent work that the FTC has done here in terms of using classifications like MPE or PAE to produce stuff. But I think that there are some problems, perhaps not in that report, but in many others that I read that use these terms. I think people are not often clear on what exactly these terms are or how they're different, and I think often people use them interchangeably or in ways that make it difficult to understand. At some level, it requires looking into the soul of the company to label them, I think, and that introduces some problems as well. So as a solution for this, one lens that I think is really good to use to look at this litigation is to ask the question, is this a case that's filed by a party who files lots of cases? Is this a party who files at least 10 cases within a 365-day stay? And this is a metric I think has some advantages. It's behavioral based, it's purely objective, there's no application problem. And I think it correlates really well with some real world concerns, namely companies who sue a lot of people are more likely to sue you. So what does this tell us? What comes out of this? First of all, high volume plaintiff litigation opposed to low volume. So the people who file lots of cases, this really drives the volatility in case filings, both in terms of time and in terms of district. I'm going to show you in just a second how sensitive high volume plaintiffs are to legislative developments. And it's really, I think, remarkable to see that. And last, high volume plaintiffs really drive the preference for district, and especially Eastern Delaware. And I think the Eastern Texas, and the trade-off between Delaware and Texas. So this chart, and again, I apologize for the small text here, but this is worth looking at. The top section is all districts in the U.S. other than Texas and Delaware. The blue line represents low volume plaintiffs and the orange high. So in that top portion, you can see that the low volume outnumber the high volume nationally and are relatively consistent. And if you look at the bottom two charts, Eastern Texas and Delaware respectively, you can see in orange the high volume. So in Texas, that low volume blue line is relatively flat. It's the high volume orange line that's spiky. So that's where your volatility comes from. And same thing in Delaware. And again, you can see that the Delaware orange line sort of drops off in 2014 about the same time that the Texas one picks up, and I interpret that meaning that a lot of high volume activity transitioned from Delaware to Texas. So if we get rid of the district breakdown and just look at things nationally, I want to look at two particular points on this chart that may have drawn your attention, not least because they're circled. When you look at these filing spikes, it's interesting to ask what's driving this. You see them in the high volume top part here, not so much in the low volume. So I want to unpack that. The first one is a record filing spike in December. When you go behind that, it was the end of Form 18. So for a long time, you could plead direct patent infringement using Form 18. And you have to specify what patent you thought was infringed. And through a complicated series of rule changes, that went away. And the days before that form disappeared, we saw a record number of filings. A huge number of them were in Eastern Texas as well. The other spike I wanted to look at was in April of 2014. This one I think is even more interesting. A proposed amendment to a then current patent reform bill was leaked. And that proposed amendment included a cutoff date that would have affected fee shifting. And so on the strength of this leaked legislative proposed amendment, let me make sure I say that right, we saw a record number of case filings. Indeed, yeah, 688. So these two events, I think, those two huge spikes that you see in this chart correspond to particular legislative developments and show the sensitivity to this. And so The last point I want to make is that those are really driven by high volume plaintiffs. In looking at high volume plaintiff outcomes, so it's all great to have this distinction of high volume versus low volume, but what does that really tell you? What's the takeaway here? And I think it's interesting to look at how that breaks down in terms of outcomes. So for high volume plaintiffs, it's actually interesting. It's hard to read, but they actually prevail slightly less in Eastern Texas, 0.6% to 0.8% for claim defendant wins. And that's maybe not what some people would expect, and it's the reverse. In other districts, on average, claimants win more often. So I think that's an interesting point of comparison. I would also look at the low volume Eastern Texas, which is very consistent with sort of the high volume international pattern. I think the last point that's worth looking at here is the settlement rates. And for high volume plaintiffs nationally, that settlement rate is about 70%, but in East Texas, it's about 85%. So with that, sorry, I didn't want to.
No, that was great. So we're just getting the train rolling here. We're going to come back and weave this in. We'll get the PTAB report and the FTC study. But I did want to take this opportunity to note that there's been a dramatic change in the overall patent system that Chief Judge Prost noted as well. I don't know if she mentioned this, but the Federal Circuit is now seeing more PTAB appeals than district court appeals. About 40% of their cases are PTAB, about 35% are district court appeals. And that is really a major shift. We've had re-examination since the early 80s, but it really wasn't until the AIA and the IPR that really took off. And that brings us to our next part of the case, the new kids on the block. So who are the new kids on the block? Well, we have them here with us. Scott, you don't look the same as back in the, your earlier
I had
days.
more hair back then.
Yeah, okay. But it is, it is this major shift. And I see it in a lot of ways in teaching. And the lawyer from Steptoe who earlier asked about the future, well, this is the future. It's happening right now. And so a lot of my students who have tech backgrounds, I say, make sure you get your, make sure that you qualify to practice at the patent office, because that's what the law firms are all looking for. And even if you're doing district court litigation, there's almost always a parallel PTAB, especially in some of these high volume cases. So, for at least the foreseeable future, this is going to be a major focus of our patent system. I remember when it first developed, a lot of the big law firms that were doing the district court litigation, they were unsure whether they were going to move into this. Their feeling was, that's sort of a quicker, dirtier process. We're trained trial lawyers. We don't do that. Well, they all do it now. I mean, every major law firm has a PTAB group, and it is just central. And we're going to get to hear Julie talk about what it looks like from the litigator perspective, trial lawyer perspective. And we're going to talk with the district judges about how the stay process is unfolding. But let's hear a little more about this process. So the major sort of change, what made IPR much more attractive than re-exam, is that Congress put in a timeline. It said that institution decisions have to be made within 6 months and then another 12 months to reach a determination. Now, I will say, and this is something that the district judges are concerned about, that the 18-month sort of end date isn't really the end date, because there can be appeals. But compared to the earlier era, and I'll just give you an example, one of my favorite examples. So one of the most important patent litigations of the, I would say, modern era involved Research in Motion. And when they were sued over the BlackBerry, they immediately filed for re-exam. But that process was so slow that they were never able to really get any good re-exam results prior to the risk of an injunction. And so they ended up settling the case for over $600 million. And I think it was really, it really brought out the unfairness of not being able to get a prompt review at the patent office. So we've now corrected that, but that's created a whole other sort of strategic game. And we're going to
hear more about what happens at the PTAB. Scott?
All right. So thank you, Peter. Do you want me to go?
You can
I'll go
take
up
it
here.
wherever you want.
I'll go over to the.
I'm hoping we're going to see some dance moves.
You could, because apparently.
Yes, well, thank you, Peter. You know, I won't question your taste in music, except to note that I'm also a child of the 80s, so maybe from that we can take that perhaps the PTAB has the right stuff, and that although we're maybe not teen idols, maybe in 30 years we'll be touring the country with other tribunals of our day, so.
Yeah,
But-
Old Cello was great.
Yes.
You know, you guys can perform there.
Yes. But thank you. And while there are some statistics here in the presentation and in your materials, I'll stay a little bit away from some of the statistics, not to ruin the surprise, but in the next panel, Judge Rama Elaru also has some of the very same statistics, so I'm not going to steal her thunder entirely. But what I would like to say, and something that I tend to like to bring out whenever we have presentations that are very statistics heavy, is that statistics are all great and all that. They give us very interesting information about sometimes what's going on in the overall or the very high level sense, but never forget that good advocacy is what really counts. And never forget that your case is its own case. It has its own facts, its own strengths and weaknesses. And just because the statistics say one thing, really doesn't mean your case is going to naturally follow that. The odds may be very different, and you've got to take a hard look at your very own case, the pluses and minuses of that, because good advocacy is always in style at the PTAB, as well as any other tribunal, be it a district court or the federal circuit or anywhere else. So please don't forget that as we dive into statistics. The other thing is with statistics, and I found especially in the area of AIA statistics, you really have to understand that trial process that Peter brought out to know what are the statistics telling you. I've heard some, frankly, very wrong things being said, and I think they come from a misunderstanding of the process and what happens at each stage. So again, just be careful when you're looking at that. Another thing to note, and this is something I don't hear much about, we do hear the statistic that there's about between 80 to 90% of all of the inter-parties reviews at the PTAB have parallel district court proceeding. Don't believe the converse is true. In other words, there's a whole lot of district court cases that have no corresponding PTAB proceeding. And I mean, just taking a look at the slides that were up there earlier, I kind of just roughly tallied somewhere around 20,000 district court cases filed since the AIA, more or less. And, we've only had roughly 6,000 cases at the PTAB filed. So just I think that alone tells you, again, with anything, there's probably a lot of nuance into poking into that. But so with that, I'll just go ahead and begin. The thing that I'd like to show you here is that from the very beginning of the AIA through the end of September is that we've had about 5,600 total cases filed, and that 90% of those are IPRs. About 8% are the covered business method cases. One thing to note on that is as we move in later into the panel on stays, there is no stay provision in the AIA for IPRs, but there is a stay provision in CBM, but note that the number of those is far fewer than the IPRs. The other thing that I'd like to note on filings, this just shows you the domination by technology. Again, they're largely in the electrical area, but the biotech chunk has been growing. We've noticed that's a trend that we've seen. I'm not going to talk about the preliminary response rules, but I will just note that the institution rate has been coming down over time, which is, I think, another thing that plays into the stay decision is recall that the very first stage of our AIA trials is a preliminary decision basically on petitioner's case in chief. The petition is the case in chief of petitioner. Patent owner has a limited chance to hack away at that in their preliminary response, but it's really after institution that patent owner gets to put on their case in chief. And so the decision on institution is really one just made on the state of the facts at that time, but we realize that those have not been fully developed. The case filings over time, and I don't have this in here, but they have pretty much leveled out. We are seeing a leveling of inter partes reviews. The CBMs have actually gone down this year over time. And so that may play into the fact that originally we saw this tremendous ramp up right after the AIA passed. Up to a level that was really beyond what we'd expected, but in at least over the past year, it's been pretty steady. The board has sufficient resources to handle the current volume, even a little bit more. I'd say that actually half of the judge time is spent on our other major area of jurisdiction, appeals, of which we have about 15,000 in our inventory. But about a third of the judge resources at the board are spent on AIA trials. So we've got additional cushion should there be a spike in an uptick. We're not anticipating that, but we don't really know. Another thing that's sort of interesting is that the institution rate may depend on the technology area that you happen to be in. But in any event, in each case, I would say that the board panel takes each case seriously. We look at each one on the facts and the arguments that are presented by the parties. So I would say don't read too much into the statistics if you have a particular case. Look at your strengths and weaknesses. Something else that I wanted to mention, and this is just something that I've heard anecdotally from Chief Judge Lynn in the Northern District of Texas, but there was also a presentation at the East Texas Bench and Bar from it was someone by Apple that basically sort of the gist of it is that a lot of the cases that come to the PTAB end up resolving disputes in the district court almost no matter who wins. So I thought that was interesting. Those aren't my statistics. Those are presentations of someone else, but I think it's something that, to Chief Judge Prost's point about how is this playing out in the overall system, something I think certainly bears some looking into. I'm going to spare you the stepping stones and the cylinders today. I'm also going to spare you amendment practice, which I don't know is really not such a great fit for this current panel, but is probably going to be a hot topic in the next panel. So I'll let Judge Elleroux talk to you about that. And so with that, those are sort of the high points of where we are at PTAB and sort of how we see ourselves fitting into the overall picture. So thank you.
Great, thank you. So we're going to transition into how this affects the district court. So I want to just say a few words about the bridge. This chart tries to just summarize in one image the overall strategy surrounding the PTAB. We're dealing with somewhat different evidentiary standards. I mean, we've got, the Quozo case now. We don't look at the entirety of a case for IPRs. There's very little PGR activity, and I think that's going to largely remain just because there's a collective action problem. If I challenge a patent before there's any litigation, I'm essentially subsidizing my competitors who might also be sued. So unless we see more sort of coordination among prospective defendants. I don't think the PGR process will play nearly the role that the IPR process does, which is a way to essentially bring in another tribunal when there's active litigation. But if you notice, the IPR process is only looking at patents and printed publications. Also, it's only looking at 102 and 103. So it's a much more limited view. And that's, in some ways, an odd approach when you compare to, say, other parts of the world where you get a full review of validity. Here, you're just getting a fairly limited review, but you're getting people who are very familiar with the kinds of documents. These are patent office professionals. They are trained as scientists, technologists. The big sort of issue, if you're a district judge, is going to be, will this produce an estoppel effect? Is it essentially going to avoid me having to do all of this work? I mean, if the PTAB invalidates the patent before you finish your case, you've essentially burned a lot of effort, and so that, because of the faster speed of the PTAB process, has produced a lot more stay interest. So the basic test is a three-part test, and it asks whether a stay would unduly prejudice or present a clear tactical disadvantage to the non-moving party, whether the stay will simplify the issues in question, and whether the discovery is complete and whether a trial date has been set. Very practical issues. District courts have been issuing opinions on the application of these factors. I'm going to skip some of those details just to get to kind of the patterns, and then we'll turn to Julie and then to our district court judges. So you can see that there's been a large uptick in stay requests, and you can see that from the blue bar that there's been an increasing number of stays. And I remember when the AI was first announced, many district judges thought it's going to be business as usual. This is not going to really change their approach, which was to be skeptical of staying patent cases given the traditional long delay at the patent office. But I would say that view has changed among the district judges. They've, in some ways, come to appreciate a little more how this does relieve them of some work. And also, some judges have expressed surprise and discomfort when the lawyers don't fully apprise them of what's going on in this parallel jurisdiction. So we're seeing this increase. When you look in terms of the overall statistics, the NPE type cases result in a higher percentage of stays being granted. And when we look across districts, you can see there's some variation. Eastern District of Texas thus far has had a lower stay rate, but they have a somewhat different caseload than other districts. And so these patterns are becoming more robust, or at least we're getting a lot more data. Another big issue has to do with the institution decision. Prior to institution, a stay is less likely. Post-institution, much more likely. And it creates the possibility of doing a partial stay. We're going to wait. The institution decisions come within 6 months. It may just be a month or two once the stay petition has been filed, and so courts are willing to at least wait that out. In terms of sort of the big picture, what I'm seeing is that the timing, the types of issues presented, the estoppel effects, and whether or not parties agree to be bound, even if they are not themselves pursuing the IPR. And that's a very big and interesting point of leverage that judges have. They can say to a party, you want to stay, but you're not willing to be bound by it. Why should we give you, 2 bites at this apple? And so I think that this idea of conditional stays and allowing the parties to explain why, or asking the parties to explain why they're not going to be bound. And also, sometimes you have some issues that are within the IPR and some issues that aren't. And so if you're going to have to go forward with the ones that aren't, maybe you should just go ahead. So these are the kinds of discussions that are happening. And I think, when you look at the statistics, they're often driven by party choices. If they're not willing to be bound, then the stay is less likely. So this is the matrix we see. Julie, you want to tell us a bit about what it looks like to you in the trench?
Sure. What we've seen over the last few years is that in any serious case, PTAB proceedings, and in particular IPRs, are part and parcel of your strategy. And let me just start by explaining what I mean by a serious case. As Judge Bolick said quite correctly, not every district court litigation is going to have parallel PTAB proceedings. And that's because PTAB proceedings, while much less expensive than district court litigation, are still not inexpensive. You can spend a few to several $100,000 on an IPR. So if you look at a case and say, this is a case that will probably settle for 5 to the low 6 figures, it makes no sense at all to file an IPR. So turning then to the type of case where you will file an IPR, what I would consider a serious case with high stakes between competitors or against a licensing entity that will go to trial, you have to have an integrated strategy and an integrated team, and you have to take a trial approach to the IPR. And what I mean by an integrated strategy and team is you need to have the same people looking at the claim construction issues and at the prior art to avoid conflicts between what is happening before the PTAB on the one hand and what's happening in the district court on the other hand. So the first question you have to look at is, are you going to file an IPR at all? And that really depends on the quality of the prior art that you have. If you have good prior art, 102 or strong 103 prior art that's going to cover either all the asserted claims or at least all the claims that are sufficiently broad that you're going to have problems with non-infringement, then it's worth doing. If not, it simply doesn't make any sense to do it. It's a waste of time and money, and furthermore, you're facing an estoppel. As I think Judge Prost was saying earlier, the scope of that estoppel is not yet clear, but why risk it for zero benefit? So you have to look at the quality of the prior art, and you have to take the time to put in a quality petition. You would think that goes without saying, but it doesn't. People still do careless work, don't take the time to connect all the dots, and the petition you have to put your best foot forward because it's really your only chance. Once you've decided that you're going to file, the next question is going to be timing. When do you file? Up till a complaint is served, you can of course file any time if you're in licensing negotiations. Once the complaint has been served, you have 1 year. And typically what we recommend is that you file as soon as you reasonably can. And the reason for that is twofold. One is, of course, you're more likely to get a stay if you file early. But the other is you're much more likely to get a resolution before trial if you file early. As was mentioned earlier, it takes 18 months, or sometimes less, depending on the preliminary response, to get to a final written decision. And very few district courts will get you to trial before that. So you've got much better odds of getting a decision if you file early, if you get a final written decision before you go to trial. If you delay an entire year, you could very well end up in trial in some districts before you get a decision from the PTAB. So generally, it makes sense to file early. There can be advantages to delaying. One is that you'll get a preview of the patentee's strategy on validity. What are the weaknesses in your prior art? What are the arguments they're going to make? And you can preempt those. Also, depending on the timing, you could end up getting 2 bites at the apple. You could get to make your argument on invalidity in district court, and then again in the PTAB. On the whole, the advantages of delaying are outweighed in most cases by the advantages of filing early. So better generally to file early. And another significant consideration is the tensions between what's happening in the PTAB and what's happening in district court. You have to make sure your claim construction positions are, if not identical, at least consistent and explainable. You do have different standards there, but it can often be difficult if you and your expert are taking different positions before the PTAB and before the district court as to claim construction, and certainly, of course, as to what the art discloses. You have to consider whether or not you want to use the same expert. Typically, it's a good idea, but not always. The advantage of using the same expert is he will understand the case as a whole and hopefully be able to thread the needle when you have tensions or conflicts between the two forms. On the other hand, if you have the same expert, he's going to make statements in both cases, and you're going to end up being bound by those. So that's another important point that you have to consider. And one final strategy point that I would like to point out is if you have a serious case and you're a defendant, you want to put some pressure on the plaintiff, one thing you might do is not merely file IPRs on that plaintiff's asserted patents, but also on patents that are strategically important, but not at issue in your case. You can do that to put more pressure on the plaintiff and to drive a settlement. So those are some of the kinds of considerations that we look at when litigating a high-stakes case and considering what to do with the PTAB.
Okay, thank you, Julia. That was great. So I want to now turn to our district judges, and they bring a tremendous amount of experience. They come from somewhat different places geographically, but also career-wise. Judge Gilstrap is unquestionably the fastest learner in our entire patent system. I remember meeting him soon after he was appointed by President Obama in 2011. He was coming into a district court that was already, very steeped in these cases, and it was unclear whether, it would, Judge Ward's docket would go entirely to Judge Gilstrap in the same way, and he, quickly came up to speed. He came to every event that he could. He learned sort of how this was all unfolding. The Eastern District Bench and Bar, you've heard, is very active, and so he quickly developed a reputation for being able to process these cases, and as they say, the rest is history. He has the largest docket in the country. Judge Robinson, by contrast, she's sort of seen the full arc. She was appointed really before the patent explosion occurred. I don't know that patent was really part of her life. Prior to this, she was at the U.S. Attorney's Office. She was a magistrate judge, but she's been on the bench a very long time. In fact, she was the chief judge of the district as this transition was unfolding. Really right before the dot-com bubble burst, and we saw a lot of this litigation. She was elevated to the chief judge job and had that well into the 2000 period. And so I've enjoyed hearing her on panels over many years, and so she's sort of seen this ebb and flow. The stay issue is kind of a new issue. As I said, 5 years ago, it was not something that we would have focused on in an event like this, but now it is a central issue. So I'm not sure who we should start with first. Maybe Judge
She
Robbins.
told me I had to go first.
Oh, okay, then.
And she has seniority, so I guess I have to go first.
Yeah, that resolves it.
Well, let me just say before getting into the stay issue, everywhere I go, I hear this. He has the largest patent docket in the United States. When I came on the court 5 years ago, I was the 8th member of a district with 8 Article III positions, and the court was back up to 100% strength. Over that 5 years, we now have 3 vacancies out of 8. We are almost 40% vacant. And part of why I have the largest patent docket in the United States is because we don't have enough judges to do the work we do. And those vacancies that have come about during my tenure have largely fallen from our colleagues that handled large patent dockets, and those cases had to go somewhere. So Judge Schrader, who's been on the bench 2 years, and I are handling about 99% of the patent docket in the Eastern District of Texas, and that skews the statistics, I think, to a certain extent. Not that I don't like the title, but I hear it everywhere I go, and I think you're entitled to a little bit of an explanation. Before we lost the 3 judges that retirement and senior status took, none of us were close to being #1 in the country. So that little bit of explanation. On the stay issue, I think what Julie said makes a lot of sense. I can tell you that in my case, the stay request is something we look at on an ad hoc basis. Every case is different. Every set of facts and circumstances are different. But from a high level, I'm going to want to know a few consistent things when you come to my court and ask for a stay of your district court case. Number one, how long into that 1 year have you waited to file at the PTAB? Have you waited until the 11th month of those 12 months? And are you indicating to me you're trying to get 2 bites at the apple? Because most district judges don't smile at litigants who are trying to get 2 bites of the apple. We have this theory called res judicata, where you're only supposed to get a trial one time. So 2 bites at the apple is strategically a great idea for lawyers, but judges don't usually warm to that concept. And if I think you're trying to get 2 bites at the apple, it will probably not help your chances of getting your case stayed. So I'm going to want to know, how long have you taken before you went to the PTAB? I'm going to want to know, is your petition at the PTAB, has it been instituted or is it just pending? Because if it's just pending, you're asking me to stay a live case on the prospect of something in the future that hasn't happened yet. And that's much less compelling than when an IPR has been instituted and there is a live PTAB proceeding that I know is going to go to conclusion. Those are very different circumstances. So I'm going to want to know, is it instituted or is it not instituted? And then the other thing I'm going to ask you, is it instituted on all the claims before me, or is it only instituted on part of the claims before me? If you've got a case before me with 3 patents and 14 claims, and you come in and say, the PTAB's instituted review, Your Honor, and I say, how many? They've instituted review on 1, and you still have 13 claims you have to try, that's not compelling for a stay request. If they've instituted on all of those claims, or the vast majority of those claims, that's much more compelling. I try to look at these from an inherently practical standpoint. And even though I've heard people argue the AIA turns judicial economy on its head, judges still look at judicial economy as a important concept. Am I going to waste a lot of time and then it's going to get wasted by something that happens elsewhere? If you can make me believe that's a likely possibility, I'm going to seriously consider your stay. But if I've got to try a lawsuit to conclusion and a verdict at some place, regardless of what happens at the PTAB, and it's not just the last weakest claim that's still left in the district court, but it's a substantial portion of the claims and perhaps some of the stronger claims, then the parallel proceeding is much less compelling for me to grant a stay. I know the factors that were put on the screen, and we do look at those factors, but what I'm trying to give you is a little bit of the context between the lines of those factors. Have you waited? Are you sitting on your hands, or have you acted promptly? Have you asked me to spend a lot of time on your case, and then 11.5 months later you want me to stop everything because you've decided to go to the PTAB? That's not a winning argument for a stay in my court. Has the PTAB instituted review? If they haven't, save your ink and file your motion later. If they have instituted review, is it the majority of the case, if not all the claims, and can you tell me in good faith this is going to make your case go away, Judge Gilstrap? If you can, that is a very pleasant thought and one that judges warm to. But when you tell me they've only taken 2 of these 14 claims and you've got 12 of them left, then I know at the end of the day, in all likelihood, I've still got a lawsuit to try. And so the reason for granting a stay of the entire lawsuit is not compelling in that circumstance. So it depends on what the facts are. Everyone gets looked at on its own merit. I don't think, no matter what the statistics are around the country, and statistics are what statistics are, I'll just stop at that. But no matter what the statistics are, if you've got a compelling case on those type questions, then you're probably going to get a stay. If you don't, you're probably not going to get a stay. I will say one thing, at least in my district, from the time you get to the initial scheduling conference until you get to jury selection, we're running about 16 months. So you may well get a trial in the Eastern District of Texas before you get a decision from the PTAB, depending on how long it takes the PTAB to decide whether to institute or not, and how long your case has been filed before we get it in and get it scheduled with the initial scheduling conference. But all things considered, that's a general high-level overview of how I take up the issue. I will, since we're on stays, I will mention one other thing, and that is, it seems like lately I've gotten a lot of requests for stays from litigants who are not before the PTAB, but somebody unrelated, a third party, is before the PTAB on the same or similar claims, and they want me to stay their case because of the potential outcome of the PTAB proceeding. And inherently, I'm going to ask them, are you willing to be stopped to the same extent those litigants are willing to be stopped? And consistently so far, I have not been, I'm not been persuaded by people who answer that question no. If you're willing to be stopped to the same statutory degree that the movement is, then I think that's a good faith position, and I'll look at the stay request carefully. If you're going to give me some kind of what some judges have called estoppel light, we'll be stopped, but not quite to the same extent, and we can still do this and we can still do that. That's not a compelling argument, at least to me, with regard to a request for a stay based on a third party's PTAB proceeding. When you say we'll be stopped to the same extent that the third party presented their prior art to the PTAB, well, if it's a prior argument based on 6 references and you only have to tweak one little element and then you can say it's a different reference, it's a different combination altogether, it's not the prior art that the PTAB saw, I'm not stopped, I get to argue it all over again at the district court. That's the kind of potential problem that I see with anybody coming in asking for a stay based upon something other than a willingness to be fully stopped to the same statutory level as the applicant is before the PTAB. I've gotten a lot of those lately, and that's pretty much at this point the position I've taken and the reason why. So that may or may not be of some interest, but I thought as long as we were on stays, I'd mention that.
Great. Judge Robinson?
I don't have a lot to add. That's why I let him go first. I did
You
want
told
to
me to go
I
first.
know.
Judicial
You didn't ask me, you told me.
I did. I'm just going to add 3 points, and they're really points of emphasis. I won't stay until an IPR has been instituted, but I think it's important for you to let the court know, or at least me know, that you filed it so that you don't seem like you're delaying. And generally, I think the lawyers who appear before me will send me a letter, just kind of a notice. We filed something, so that when I get the stay motion, if it's instituted, then I have that context. The second thing is truly trying to compare the scope of what's going forward administratively versus the scope of the litigation, and trying to see who's in the best position to give the parties a resolution to their dispute. And that's not always an easy thing to do at the outset of a case, but that is something that I think we struggle with in terms of staying. And for someone like me who has been on the bench since '91, and we, re-exams that just went on forever and ever, it's been an adjustment for me, because I grew up justice delayed is justice denied, and it was always get to trial, get to trial, get to trial, and all of a sudden we have requests, well, don't go to trial, sit back. And so it's been a struggle to try to figure out what's best for the dispute and for the parties in terms of getting to a resolution. And the third point I'd emphasize is just this whole estoppel. Well, 2 more points. The estoppel, if you're asking me, especially as a litigant who isn't directly involved, to stay, then you need to make sure you give me something back. And I thought the fourth thing I just wanted to emphasize is something that Julie said, and that is that you really do have to be careful when you're doing these parallel proceedings to have consistent positions, because they can be used quite effectively in litigation. So that's something you have to be very mindful of.
Mm-hmm. Well, I think this has been, a great example of what we try to do in this conference is sort of connect sort of what's happening out in the real world, with some of these evolving policy issues. And what I want to add, just to kind of put more of an academic gloss or a longer-term gloss, the AIA was a big experiment. And I have to say, no one expected, even the Patent Office, expected that the IPRs would be as popular. In fact, you can find legislative history and other materials that's, said, we might not sort of get fully up to what we expect. Well, the real world has taught us a lesson. It's been teaching us a lot of lessons lately, but I'll leave that to the side. But certainly on the AIA, this, there was a lot of sort of pent-up demand to try to get faster processing and getting the PTO involved. And so we're now sort of seeing that trickle, but we're also seeing, I'll say, unanticipated or unintended results, which is that we have a very odd property right now. When you think about sort of land or other resources, you can usually go in and quiet title. You can usually get some way to figure out whether this title is valid against the world. And I think the PTAB process is creating this new reality, which is that a patent can be attacked at many points by a variety of people, and especially in the biopharma space, where security of investment, security of rights really drives very big outlays of money. This is causing a concern. And when I think about it, it connects to one of our Supreme Court cases that you remember from federal courts, the Blonder Tongue case, and who's going to be bound. But I think we need to move to a system where there is some finality through the PTAB. And I know that at the Patent Office, they're starting to talk about that. I've spoken to Michelle Lee about it. And this idea that, in some ways, we ought to be able to call everyone who might challenge it, and do it once and finally. And I think that's what the district court is also getting at. We need to come up with a way to really, and only if the patent is invalidated, it is final. But if it's not invalidated, it's continually subject to attack. And from the standpoint of how investment and incentives work, that creates a concern. So I see this area as still, I think we'll be talking about this over the next several years as we move down this path. But this is, I think, a really clear sense of how that path has moved, and we'll find out in the coming years where it's going. So we're going to turn now to this study that Suzanne Monk led. I'm going to let her take the stage, and we'll get through the details of that, and then hopefully we'll hear from our judges.
Thanks. Well, thank you very much for inviting me here today. If you've heard from the government, these are my own views and not necessarily those of the commission or any commissioner. I also want to acknowledge the work that two of my colleagues who are in the audience did on this project, John Dubiansky and Elizabeth Gillen. Their work was central to being able to analyze all of the information that we collected. And in particular, when I joined the FTC in 2007, I had never done a PAE case. I had done competitor-to-competitor litigation. My focus was primarily on damages. So I was very lucky to be able to hire John Dubiansky, who had litigated PAE cases and joined us in 2013, to have a real-world perspective of what these types of litigations looked like as we were going through the process. So I just want to take a minute and acknowledge their contributions, together with the very strong contributions of our Bureau of Economics, because this was a joint project between OPP and BE. I'll be talking about a lot of the high-level points here. I have about 10 minutes, but I really encourage you to take a look at the report, because you'll see a lot of very interesting charts and graphs looking at information that no one else has been able to collect. So moving forward, what we're talking about when we're talking about patent assertion entities are folks who are acquiring intellectual property from third parties with the eye of asserting it against folks who are already on the market, not companies who are developing the IP in-house and then asserting it, not manufacturers. And one of the points that was raised earlier was, how do you know if someone is a PAE or not? We were in a very unique position here. The FTC has the ability to compel the production of information that is not for a litigation purpose. So we actually spent a significant amount of time combing through Secretary of State information and other records to identify companies that we believed were PAEs. And then once we reached out to them, we were able to have that conversation with them. Are you in fact a PAE, or are you asserting IP that you developed in-house? And we were able to screen in that fashion. So there were some folks who received information requests from us who were not part of the study. So I do believe we were able to focus on companies that had at the core of their business model this assertion, acquisition and assertion behavior. Now, some people will say, PAE behavior is a verb and not a noun, and you could also have manufacturing companies who are engaged in PAE activity within some arm of their behavior. And I think that's true. I think we've heard about that anecdotally, but the folks within our study were sort of the pure PAE model. The report that I'm talking about was voted out unanimously by a bipartisan commission. I think that's really important in the current political climate. I also think it's important because if you follow the FTC's approach to IP issues, you know that our commissioners are not unanimous in their approach to all IP issues. So I think that adds strength to what we found. It adds strength to the quality of the empirical analysis and to the recommendations. Like I said, I'm going to be talking very quickly about the report today. I encourage you to at least read the executive summary to get a better understanding of what we found. So very quickly, our study period was January 2009 to September 2014. We collected information from 22 PAEs, but we asked each of those PAEs to tell us information about any of their affiliated companies. By doing that, we were able to collect information from another approximately 300 PAEs and 2,000 entities that held patents but did not assert. This report is a case study, and we wanted to be able to tell you this is what we're seeing in terms of PAE activity, but if you asked us, how does that compare to behavior writ large, we also wanted to be able to get at that question in some respects. So we have a wireless case study where we compare the behavior of our PAEs in the wireless space with the behavior of NPEs and manufacturers in the wireless chipset space. And there too, we were talking to these companies to make sure that they were true manufacturers, true NPEs. Our manufacturers represent about 90% of the worldwide market for wireless chipsets. So you may say, okay, this is a case study. What did you observe? We observed approximately 75% of US PAE patent holdings as of 2013, between 14 and 46% of PAE infringement litigation initiated during the study period. And you may say, why is that number variable? It's because we know that we saw 8.8% of all patent litigation within the study period. But there are various metrics of how much of all patent litigation is attributed to PAEs. So if you go with the GAO data, you get to 46%. Now, there is, I think, one thing within the report that was most surprising to me. We only saw 2 business models of PAE activity. And if you look at the FTC's earlier work, we had anticipated that there would be several models of PAEs. But within all of our data, we saw very stark differences between these 2 categories of behavior. On the one hand, you have what we call litigation PAEs. Litigation PAEs were litigating before licensing. 93% of their licenses followed suit, and they were settling litigation quickly, 66% within 1 year. 77% of litigation PAE licenses were valued at less than an estimated cost of defending a patent lawsuit through discovery, about $300,000. That's something that was not known publicly, so that is one area that we're able to contribute to the broader literature. The second area in which we contribute to the broader literature is we saw a very distinct model of setting up affiliates to assert each portfolio as it was acquired. And when we were looking at this behavior initially, we had heard about this idea. You can see it through some sort of public metrics, but there was a very, very strong business model of acquiring a small portfolio, setting up an affiliate to assert that portfolio, and then rolling that affiliate down once the assertion campaign was over. So we did not see litigation PAEs saying, I'm going to focus on, you name the technology. I'm going to focus on cloud, and I'm going to acquire a cloud portfolio, and I'm going to assert that. We didn't see that type of substantive specialization typically within the litigation PAE model. Litigation PAEs were about 20% of the study revenue, is about $800,000 over 6 years. Portfolio PAEs, very quickly, were much more like the licensing arm of a major manufacturing company. They were highly capitalized. They typically negotiated the licenses without filing suit. Their licenses had more than 1,000 patents compared to the 5 to 10 patents you would see in the litigation PAE licenses. They were generating royalties of millions of dollars typically. And This is really where the money is in our study. The 4 portfolio PAEs accounted for about 80% of total study revenue, or about $3.2 billion. So quickly, when you look at our wireless case study, what we saw was the biggest distinction between the litigation PAEs and the manufacturers. The portfolio PAEs and then NPEs were more closely in the middle there. So the litigation PAEs were almost always suing before licensing. Manufacturers almost never sued before licensing. The manufacturer licenses were significantly more complex. They included field of use restrictions, cross licenses, complicated payment terms. The litigation PAE licenses were very simple lump sum payments. I mean, I think when you think about the litigation PAE model, what we saw was a very thinly capitalized business. So not a company that would be investing resources in auditing running royalties. So lump sum payments, not something that you would need to monitor over time. We wanted to look at the patents that we saw within our study. So we observed more than 37,000 patents. And using data created by folks associated with PTO, we saw that 88% of our patents related to computer and communications or other electrical and electronic behavior. So that helps us understand that within our case study, this really is an issue focused in the high-tech sector as compared to the biopharma sector. Then more than 75% of our patents were software-related or had software-related claims. What was interesting was while we saw a majority of the IP in the study in the ICT sector, we saw that it was asserted against a broad range of industries. So 10% of our defendants and 13% of our licensees, for example, operated within retail trade. And I think this goes to the question of whether or not there is an end user issue within our case study. And I think we feel comfortable concluding that within the material that we observed, there was this trend towards asserting not only against manufacturers, but also against end users. Some of our other key findings, as you may know, I spoke a couple years ago about our MPHJ case. That was a consumer protection case against a PAE that essentially was lying about its ability to acquire licenses and its capacity to sue. There's been a lot of discussion, especially on the Hill, as to whether demand letter reform will address PAE behavior. Within our case study, we did not see demand letter campaigns of the MPHJ style. The demand letter campaigns were not on their own generating these low revenue licenses, as we had heard anecdotally. Also, we saw that a small number of entities were frequent targets of PAE activity. The computer and electronic product manufacturing firms were more than half of the top 25 assertion targets, and you also saw concentration in the firms that were spending the most money. Our top 25 firms that paid the highest royalties accounted for 69% of observed royalties. Now, one disappointment I'll say with the study is throughout this process, the FTC has been very interested in understanding the harms and efficiencies of PAE behavior. I'll speak personally. I believe strongly in the patent system, and I think that you want to make sure that you have a robust patent system that's able to be benefited by everyone within the ecosystem. And so we did ask a lot of questions that were meant to get at, is the PAE model an efficient outlet for independent inventors? And what we found was the data maintained by the PAEs was not sufficient to allow us to draw conclusions there. So we're not reporting on how much revenue PAEs shared with others or the costs of PAE activity. Now, one of the interesting things that we've done here is to make recommendations based on what we saw. So we saw a strong focus among the litigation PAEs of early stage litigation, early settlement. And we looked at the landscape of patent reform, all of the different issues that have been proposed, and we matched that against what we were seeing in our data set. So we saw, as I mentioned, 93% of litigation PAE licenses are following a lawsuit. 77% are valued at less than the lower bound of defending a patent lawsuit through the end of discovery. And when licenses followed litigation, they tended to settle early. So that led the FTC to really recognize that infringement litigation is important for protecting patent rights, but when you see this behavior that's consistent with nuisance litigation, that's not saying that all of these cases were nuisance litigation, but you see behavior that's consistent with nuisance litigation, and you know that that can tax judicial resources and divert attention away from productive business behavior, it's something to focus on when your mandate is to understand the competitive environment of the PAE business model. And I think it's interesting too, because as I've been sort of on the speaking circuit for this project, I've been hearing a lot of what Judge Gilstrap was saying in terms of judicial resources and folks feeling like the bench is not fully staffed. And so that really, I think, adds to some of our issues with respect to trying to make sure that folks are not taking advantage of litigation to achieve results based purely on that threat of litigation and not really taking advantage of the full benefits of the court system. So we propose reforms that at a very high level are directed towards lowering defendants' costs. We don't want to get in the way of folks who are bringing litigation. It's not intended to, make things more difficult for plaintiffs as they move forward, but we want to address the discovery costs imbalances between PAE plaintiffs and defendants, provide the courts and defendants with more information, streamline cases, and Form 18 is gone. I think that's a wonderful improvement, but notice has always been a very important issue for the FTC, so we want to continue to focus on notice. And just quickly on the providing courts and defendants with more information, what we did there was we saw that companies were setting up, shells or affiliates, and we looked at how courts are handling this, and we saw that the Eastern District of Texas in your local patent rules has an amended Rule 7.1. And so we make the recommendation that other courts might want to adopt that, because I'm not in the business of case management, right? I'm a researcher, I'm a policy person, I'm a litigator, but we wanted to look at how courts who are handling these issues have addressed that problem and use that as our metric for recommendations. So thank you very much.
Well, that was, I thought, just such a beautiful exposition of a very complex subject. And it wasn't, the kind of polarized analysis of these issues. And I think you really have gotten at some valuable, and also knowing of the FTC's investigatory powers, I know that academics would love to have your ability to look into what's going on. So I'll just, I don't want to put anyone on the spot, but I am curious to just hear what our district judges who've been in this trench, and also Julie Holloway, what this report, says or doesn't say, what they're seeing from their perch. So Judge Robinson, I think it's your turn to go first.
All right. Well, I have a kind of a different perspective on all this, maybe because I've been around long enough that I still consider patents a property right, and some patents are more valuable than others. And I think it's just a really interesting phenomenon that you have the Federal Circuit saying computer software patents, just take for an example, aren't patentable, then they are, now they're not, but they're kind of coming around again. And it's really those patents, because those primarily are the patents that the big players have sold at a profit, I'm sure, to these patent assertion entities to monetize, that has created this whole upswing in the PTO bureaucracy and this whole reviewing patent rights, and all of a sudden having a status of a patent assertion entity, being this the bad boy of the patent world. So it's difficult for me to me, the most important thing we should be focused on is trying to find a way to value the patents. Clearly, a lot of these patents shouldn't have been patented in the first place, so that's something that we already talked about to some extent. But valuing the patents in a way that the big players that we get as defendants all the time who are unwilling to even sit down and talk because this is considered nuisance litigation, even though many of them have invested in this very kind of business model. We need to value the patent so that the value of the patent is consistent with the cost of litigation to get to the value. To me, that's the challenge, and I don't like having status litigation where if you're one kind of plaintiff, you kind of get treated one way, and if you're another kind of plaintiff, you get treated another way. So I'm not sure that I've answered any question, but I think valuation is the key, and I'm not sure I've come up with a way of doing it because some of the big players don't even want to play. And when you don't have both parties playing together nicely, then it's hard as a district judge to get a good result.
So if I can just quickly sneak in a plug for tomorrow's morning session, where we're going to talk about patent damages, and I think you'll see that that is a very thorny bush as well. And so we're a bit stuck. But I agree with you, and I think that especially as we're getting into later sort of stages, trying to understand friend and other sort of features of the system, how we're going to come up with a way to put prices on these things. Judge Gilstrap?
Well, I think Judge Robinson makes a valid point. I too look at patents as property, and that's what the law says they are. And I've heard a lot of litigants argue over the time I've been on the bench, well, Your Honor, the plaintiff doesn't make anything. Well, I understand that, but if I own 50 acres and I don't grow crops on it and I don't raise livestock on it, if I own that 50 acres and you're trespassing across it, I still have a right to stop your trespass. It's still my property, whether I do something with it or whether I let it lay fallow. So to me, the question is not, does the plaintiff make something or not? The question is, does the plaintiff have a meritorious or substantively probable infringement argument? Is the person crossing your property? It doesn't, to me, the critical question is not, are you manufacturing something? Are you producing something? Are you making something? You own the patent. If the patent is patent eligible, which by this time in the litigation, we've already gotten past that issue, or we don't have any litigation anymore. So if it's patent eligible, the real question is, do you have a meritorious infringement argument? If you do, then you have a right to litigate, and you have a right to stop the trespass or the infringement on your property. If you don't, and if there's no real probability or merit to your argument, if you're filing suits just to settle suits and not to litigate and assert substantive rights, then there's no place for that in our system, and that is an abuse of the system. And in my view, that's what 285 is a valuable tool for us to use in that regard. The hard part is knowing the difference, and the hard part is the thing that we judges get frustrated with sometimes is we have litigants come into our system, they file a complaint, and the next thing we see is a motion, agreed motion to dismiss. Well, we don't know if there was real merit to that lawsuit. We don't know if it was totally frivolous and they settled for defense cost or less than the nuisance cost. And we're not in a position to really address that. It comes and it goes before it really gets before us. I'm confident in my court and in all the other active district courts where there are substantial patent dockets that I know of, when the cases get before the judges are going to look and see, is there some merit to this assertion of infringement? And if so, they're probably going to get to have a trial. If there's not, then the case is probably not going to get to trial, and the other tools in the toolbox, including 285, may well come into play. Both are out there, no question about it. And the problem is that, A, we have to have an opportunity to have hands-on interaction with those cases if we're going to tell the difference. And two, we can't paint with too broad a brush. We can't say everybody that doesn't manufacture something is a bad boy, is an NPE, a troll, to use that word. and they shouldn't have a right to come in and participate in the litigation system. We can't paint with too broad a brush. There are litigants that don't need to be in the system, that are gaming the system, that are using it for purposes other than what it's intended and consuming resources that are sorely needed in other places. There's no question about it. There are also very valid litigants who have a property right that they're legally entitled to enforce that don't manufacture anything. So again, my view is it's a property right. Do you have a plausible infringement argument? If so, then you're part of the group that should be in the system. If you don't, if it's inherently meritless, then you shouldn't be in the system. And at the point in the process where those cases, if they survive long enough to get to us, that's where judges, I think, can be a valid part of addressing the problem and letting the third branch deal with the issues that the third branch has before it. But that's at least my take on it.
Julie?
Well, I think Judge Gilstrap and Judge Robinson have really, hit the nub of this. The question is not who is the patent owner and are they a good entity or a bad entity, but does the case have merit? At the same time, there's no question that there are a lot of cases filed where, yes, the complaint is filed and then there's agreed, motion to delay the answer, motion delay, motion delay, motion delay, dismiss. And I've seen plenty of those cases. They do not have merit. They're being settled because of the cost of litigation. They're being settled for very modest sums. And that is a truly parasitic activity. And I think it's a very difficult issue to deal with. It's a hard problem to get rid of because, for example, fee shifting is not an option. As Judge Gilstrap said, they don't even see anything about the merits. The court really can't do anything, but that is a tremendous waste of time and resources. The only thing I can think of is working on tools for early resolution. I think Section 101 at the pleading stage, I know Peter has some views on that, but that does help to get rid of a lot of truly meritless cases early on. At the same time, it's a difficult new area of law for everyone to deal with. I've occasionally had very early claim construction on one term for summary judgment to help get rid of a case early. And that'll help with cases where the plaintiff is willing to settle for a few $100,000. They're not going to spend much, but that won't help with even the lower end nuisance cases where you're looking at, 5 to a very low 6 figures. It's hard to litigate anything for that kind of money, so it's hard to know how to deal with cases of that sort.
So I want to connect a few dots.
Can I interject one
Sure.
thing real quick? And I think Julie hit on a valid point. My practice, and I don't know what other judges do, my practice is when your answer day comes, I'll give you one extension that's unopposed. But I say in that order extending the answer date, no further extensions will be granted without an independent showing of good cause, and the mere agreement or lack of an opposition is not good cause. Because I too have seen that extension, and then the case goes away. And I don't necessarily, I think if you've got a valid case and you've come to federal court, then yes, you may have a valid reason to need a little more time. But after that, you need to saddle up and go try your lawsuit. So I try to cut off these ad nauseum extensions and extensions and extensions. And I find that has some help. I'm sorry, Peter, for interrupting.
No. So, what struck me, and I was hoping we would sort of see some of these patterns. When you combine Brian's work with Suzanne's work, what we see is really a window into that black box. And I think that it gets at some of the distortion and dysfunction that, we now know, thanks to some of the investigatory work of the FTC, that there is this business model that's out there. And it's not an unfamiliar business model. I mean, when you have sort of games in sort of economic jargon, strategy games, when there isn't going to be a reputation cost, getting in, creating an entity, doing some of this kind of very low margin kind of work, and then getting out becomes a strategy that can work, and that produces these high volume trends and high settlement rates that Brian's observing. So I think we know that it's there, but a district judge isn't in a position to, because of due process and because of the nature of a patent right, going to be able to just sort of cut that off Judge Davis tried through a separate track to do that, but it's very hard to separate those things out at this level. Now, Julie's right that 101 has become one of the levers, but we're not going to have time to deal with it here. But I'll just say briefly that there's a real problem in the 101 area that I think is more fundamental and goes to perhaps what Suzanne was saying, that we don't want to kill the golden goose here. I mean, our economy has very much benefited from the patent system. You know, I'm someone who has studied this over my entire career, and Moore's Law doesn't happen without the patent system. And a lot of the advances in biomedicine, you know, the United States is a leader in these fields because we get a lot of investment into, but we've now seen that in the software area, it's created some dysfunction. But the thing that I'll say, and this may seem provocative to some, I'm surprised Justice Scalia didn't notice this when he was on the bench. The patent statute begins, whoever invents or discovers. Invent does not mean the same thing as discover. And it's shocking to me that the Supreme Court, without even signaling to those of us who care about these issues when they took the Mayo case, that they were about to write discover out of the statute. I will tell you as a scholar, there's lots of legislative history going back to the early 19th century that Congress always intended discoveries to be eligible for patents. And so we're now facing this problem with, how are we going to sensibly interpret? No country in the world interprets their patent system the way we are right now. And so it is, in the short run, a lever where you can perhaps solve this problem, but I think it's the wrong approach. And I think the Patent Office is struggling because they're having to deal with whole fields that don't really fit anymore. And so I see the system as sort of leaping forward. Congress hasn't yet got involved. Maybe they will. The Supreme Court got involved, but now has exited. And so, we're all dealing with smaller parts of the system, from the district court to the federal circuit to, the business strategy. And, my hope as we go forward in future iterations of this conference, that we will be able to get more of a holistic view and focus the patent system on the areas where we need investment, where capital formation is important, and sort of move us away from the areas where it is prone. I'll give you an example, because I also work in the copyright area. I remember a decade ago, sort of more than a decade, the Napster, Grokster era, there were these companies creating these file sharing services that were, with banner ads, making barely enough money just to fund having some lawyers to assert, I would say, somewhat disingenuously, a safe harbor that really they didn't fit into. And we've seen this now playing out over many years. And at least as I interpret Suzanne's work, there is something similar going on in a pocket. And we don't want that pocket to overwhelm the whole system. We don't want to see the patent system wiped out. But that's, it's a struggle. So we're going to have to end things here. But I do want to say, I think this is a fantastic panel, and I'm really honored to be part of this, and I hope we'll at least generate some discussion during the breaks, and Jay and I hopefully will get to watch this unfold over many future years. The other thing is, I want to say, I see our Undersecretary Michelle Lee, and she's going to come on talk at lunch, and I'm hoping she'll pick up on some of these themes that Judge Prost started. But I do think this is a really exciting conference, and I'm just loving getting all of this. So thank you to our panel. So we're going to take a 15-minute break. We'll come back and pursue the PTAB issues, then lunch, and then we've got a great year in review coming up after lunch.
We're very much looking forward to our next panel, and I'll leave it to Mike Lee, Senior Director of Intellectual Property at Cisco, to crank things off. Thank you.
Thanks, Jay. Hi, my name is Mike Lee. Like Jay said, I'm out in California at Cisco Systems doing a variety of different things. But before we get started, I'd just like to get a temperature of the room, like who we have in the audience. How many folks are private sector attorneys? Okay, a lot of us. How about public sector? A few. How many students we got in the room? All right, very good. Anyone else that I'm missing? Any other sector? Academia, thank you. Yeah. And how many patent litigators do we have? All right, so quite a few. So I am actually a recovering patent litigator. I've been litigation-free 8 years, but I do spend a lot of time thinking about patent litigation, primarily in the policy context. And so I'm really happy today to introduce the panelists here who collectively have a lot more litigation and IPR experience than I do, the real experts on this table here. First, to my immediate left is Judge Rama Elaru. She's been at the PTAB as an administrative patent judge, I think from the very beginning, right, since
Correct.
2012. And she's handled over 260 petitions, which is really, really impressive. On her left is David McCombs. He's a partner, and he's the chair of the technology practice group at Haynes & Boone in Texas. And he's got over 100 AIA petitions under his belt. And last but not least, Michelle Yang, who's a director in the IP group at Samsung in California as well. And she's got over 30, which is impressive in its own right because this is just one person in one company. So between the three of them, they've got many, many hundreds of cases under the belt. And I think we're going to have a really fun and interesting discussion today about a very hot topic, gotten a lot of action even this morning at this conference and over the past couple of years, and that is inter-parties review and PTAB proceedings in general. A typical disclaimer, all of our views that we're going to be expressing today are our individual views and are not to be attributed to our employers. But I think that will actually benefit us. We're going to have a really open and fun discussion today. So let's see where we're going today. We've scheduled this into 3 different segments. The first is kind of a look back, 4 years of the PTAB, and I know Chief Judge Bolick has gone through some of the slides kind of covering statistics for PTAB already. We'll be hitting that a little bit. And then we'll be rolling into the hot topics of this hot topic, a couple of the more salient issues that are being bandied about in policy circles and practitioners today. And then we'll spend maybe 10 minutes at the end talking about the future of PTAB and developing trends that are going on in our space. So like I said, Chief Judge Bolick has already gone over some statistics about where the PTAB has been in the past 4 years. So I'll turn it over to you, Judge Elaru. You've been there, like I said, from the very beginning. I think you were actually part of the very first AA petition, which is pretty cool. Now that, what, 5,000 or so petitions have come through, slightly more. What are your views on PTAB? How is it going at the office?
So I think it's going very well. I think we've sort of reached a steady state. As Deputy Chief Bolick mentioned earlier, our petition rates seem to be stable, even though there were some valleys and peaks in the, from month to month last year. When we look at the cumulative for the year, it's about the same this year as well. We've reached a steady state with the number of judges. We have about 272 APJs. 80 to 100 of those APJs work on the AIA trials. So, as I said, we've reached a little steady state with that, and we're getting more guidance from the Federal Circuit. We were receiving a lot of Rule 36s, and now we're seeing presidential decisions which give us some guidance in, in moving forward. So I think that's very helpful.
Did you want to share any slides?
Sure. So I believe Deputy Chief Bolick and I picked out the same slides to present today, but there were a few that he didn't get to go to, so I will talk about those. So the current composition of the board. At the top we have Chief Judge David Rushke, and then we have Deputy Chief Judge Scott Bolick. Under that we have 5 Vice Chief Judges. Janet Gongola is the Vice Chief Judge for Engagement, and the other 4 Vice Chief positions haven't been announced yet, and we also have an Executive Director, a Board Executive. We do have some PTAB outreach events planned. We're going to start doing the board side chats again starting in January of 2017. Also, we're going to do some stadium tours with the Trademark Trial and Appeal Board in the spring and fall of 2017. And then we'll have our 3rd annual PTAB Bench and Bar in June of 2017. And we'll do this again with the live AIA trial hearing with AIPLA. The other statistic that I wanted to touch upon that Deputy Chief Judge Bullock did not get to are number of patent owner preliminary responses. We continue to see a lot of patent owner preliminary responses, 84% of the time based on all AIA trials through fiscal year 16. We had a rule change that was effective as of May 1, 2016, allowing new testimonial evidence in preliminary responses. Between May 1st and September 30th, we had 529 cases that included a patent owner preliminary response. 40% of those preliminary responses included new testimonial evidence. And as an anecdotal note, I work on both electrical engineering and computer science cases as well as biopharma cases. So I see both technologies. And I've noticed that just from my personal docket that I've seen preliminary responses with testimonial evidence more often in the biopharma cases than I do in the electrical cases. The other slide that I wanted to touch upon was this one. I think often when people talk about the percentage of petitions that are found unpatentable, they're not looking at it in full context. For example, I hear a lot of the percentages cited based on final written decisions, and that's higher than the full context because, of course, we've already satisfied the threshold of reasonable likelihood or more likely than not for CBMs and PGRs. So I'm not sure that gives a clear picture. And so this looks at the statistics based on all the IPR petitions that have been filed to date and have reached a final disposition. And I don't mean by final disposition, I mean it's been completed, not necessarily a final written decision. Out of the 3,672 petitions that reached a final disposition, 1,901 petitions went to trial, and of those, 1,214 reached final written decision. The others were terminated post-institution or settled or were otherwise completed for some other reason other than a final written decision. Of the 1,214 trials that went to final written decision, 833 trials found that all instituted claims were unpatentable, which is 23% of the total petitions, 43% of trials instituted, and 69% of final written decisions. 189 trials found that some, but not all, the claims were unpatentable, and in 192 trials, no instituted claims were found to be unpatentable. And this next slide looks at the same data based on CBMs. And again, these are only the trial cases that have started and completed, so it doesn't account for those cases that have started but have not completed. So of 391 petitions reached a final disposition. Of those, 215 CBM petitions went to trial. Of those, 143 reached final written decisions. And of the 143 trials that went to final written decision, 117 trials found that all the claims were unpatentable. And I think this number is a little higher than in party reviews because in CBMs, petitioners can assert 101. And 54% of the trials instituted, and that accounts for 82% of final written decisions.
Thank you. Thank you, Judge Elleroux. I do have a question for maybe slide 11, which I think was touched upon earlier, the institution rate year over year decreasing. Do you have any thoughts on that?
I do think that some of the theories that I've heard is that at the beginning, petitioners were challenging the low-hanging fruit patents, and that may be the case because that, as we've indicated, the institution rates have gone down and they've stabilized. Not only have they gone down, but they've stabilized in the last two fiscal years, and I think that could be one of the reasons. And anecdotally speaking, I find that the cases are a little more closer than they used to be 2 or 3 years ago.
Yeah, I think I would agree that, like, when this process started, there were stakeholders out there that were quite familiar with reexamination practice and comfortable with it, and those companies would dip their toe in the water in terms of use of IPRs, but obviously would want to make sure that it was a very strong case, just to test the procedure. A number of others were maybe much more reluctant to go in. And then I think what has happened is that as the PTAB became much more widely used, you see now that in many more cases that involve litigation, that IPR is very much a a part of the strategy, the defense strategy. And so by its nature, if the idea is that we think we can get a better shake before technical experts at the patent office than we can perhaps before a jury, it may be that, that there's a more willingness to use the procedure, and it may not be in cases where it's always a slam dunk.
Just on that note, I also think that over time, patent owners have become a little more savvy, right? And lawyers have gotten much better in this process. And so, you know, it was a big learning curve. And now, you know, maybe both sides are just doing kind of a better job at the lawyering aspect of it.
Yeah, thanks to you both. You know, a question for you, David. I think we heard this morning from Judge Prost as well as Professor Manel about potential shift in workloads of petitioners more towards the PTAB practice now. How has your practice changed over the years now that, since the AAA was passed in 2012?
Yes, so yes, there has been a significant uptick in the use of IPRs and CBMs and at the PTAB generally. You know, a lot of times when we're involved in district court litigation, there was always the idea of, well, should we be doing reexamination in parallel with that? But largely the validity portion of the cases was handled in the district court, and we've seen a very significant shift to the use of the PTAB. And for all the reasons we've talked about, you have, you know, the different standard, you know, preponderance of the evidence, you have, you know, no presumption of validity, you have experts at the patent office that are going to be looking at the technology. So all of those reasons, including cost, for example, suggest maybe that is a better venue and potentially has more predictability.
Michelle, kind of same question to you. Like, how many, what percentage of cases, litigation cases that you handle involve IPRs in some form or way?
It's always a factor that we consider when we get sued, and most of my cases were on the defense. But I would say that it's probably, I don't know the exact percentage. I would say, though, it's less than 50% of the cases that I handle that are involved in an NPE, or that's involved in a PTAB proceeding. And that's because, you know, a lot of cases, I think Julie touched on this earlier, I've settled cases for $20,000 before. A case like that, I'm not going to spend, you know, hundreds of thousands of dollars filing an IPR petition, or, you know, we might be able to get rid of the case early on a 101 motion, or we might have a very strong non-infringement position, and so it makes more sense to go a different route. You know, and they are expensive, and you have to deal with the estoppel issue, and I'm always concerned that once we put the claims into the PTAB, you know, there's the risk that it comes out bulletproof at the end if it survives, you know, the PTAB proceeding.
So you mentioned something, I'm going to pick up that ball and run with it, and that is NPEs and how they factor into our case management strategies at Cisco and at Samsung, and I'm sure a lot of other tech companies. So let me just level set a little bit. You know, I think one of the main reasons why we even have an AAA petition practice is, you know, at least from our perspective, from the tech company perspective, you know, this issue of NPEs coming after operating companies, potentially with questionable quality patents, and there being a need in the patent office to have a cheaper alternative to invalidate questionable quality patents in a much cheaper way than what district court would traditionally afford. And so that leads us to our very first poll question. So no new kids on the block. I'm not that cool like Professor Manel. I just have a very boring magic 8-ball that we're going to ask a question to. But that is kind of testing the hypothesis that I just mentioned, which is, you know, NPEs coming after operating companies with questionable quality patents. So who fares better in the PTAB? And here we have just decided to look at final written decisions just for a point of a contrast. what do you think, which type of patent owner does better at a final written decision? A, operating companies, B, NPEs, or C, not really any difference at all? What do folks think? Show of hands. A? Few folks for A. B? NPEs do better at final written decision?
Not a single hand.
Not a single hand.
Not a single hand.
Yeah.
There's no wrong answer here. It's okay. Actually, there are two wrong answers, but no one's keeping track, so it's okay. C, no discernible difference. Okay, I think most people pick C. Well, let's see what the magic 8-ball says. Oh, they chose A. All right, well, let's see the data. This data is from RPX, and they show a slight difference where if you look at the left-hand chart, for example, for instituted claims that were unpatentable at the end of a final written decision, NPE 79% versus operating company 70%. So I think there is a slight difference there. And I'll open up to the panel. Why do you think this is? Is this surprising in any way to any of the panelists, the delta or discrepancy between patents by patent owner, in other words, NPEs versus operating company patents that are being challenged in an AIA petition?
Well, I have some thoughts and observations at the risk of categorizing things too specifically. I mean, there's really two types of NPEs, and we heard from Suzanne earlier. You have the very well-funded, usually venture capital-backed larger groups of non-practicing entities, and those folks really do. They put a lot of money and investment and time into developing very large portfolios that they bring to bear. Then you have, in certain cases, you have smaller inventors, and sometimes, not always, but sometimes the smaller inventors believe so much in their technology that they can, in some cases, be blind to maybe some defects in their patents, but they're willing to go forward and push assertions. And in the latter case, often what happens, at least initially, you had before AIA practice was available, you had a lot of contingency fee law firms that would take those cases out and either through licensing campaigns or litigation assert those patents. Right now, though, the business model has completely changed for contingency fee law firms, because you will not find any or very few contingency fee firms that will take on the cost of defending the patent owner in an IPR as part of their contingency, and a lot of these patent owners just cannot afford to do that. So I think what we do see, I believe, that a lot of these cases where the NPEs were not faring quite as well was a result of a lot of the earlier cases that were brought, which were much more questionable, where the patent owners would take much more risk. I'm seeing now, at least in our cases, that you see much less of these cases where the detritus, if you will, that just sort of floats around out there. And so I'm seeing that while the NPEs are not faring as well, because a lot of those cases were cases that they really should not have been asserting, and I think the patent reform aspect of the AIA is working to get rid of those cases. So that's why I think you see it. And the percentage is not overly huge, because I think now we're moving now towards the cases where the NPEs, they're asserting large, big portfolios, and we're seeing maybe in some cases those patents are stronger.
Also, for the operating companies whose patents end up in the patent office, those are the ones that they're probably asserting against someone. I would suspect that those are probably vetted a little more. I'm not just, operating companies usually have a larger portfolio, and so if they're going to sue someone on it, they're probably going to pick their strongest patents. And so those are the patents that might, end up surviving PTAB proceedings.
So I think part of this is we are seeing maybe less flotsam and jetsam washing up on the shores of corporate America with these assertions that are just totally outlandish. Now, they are still out there, but I think there's much less of that, and I think reform is working in that sense, because it really doesn't make sense if you're a patent owner. If you want any kind of serious return on that patent, you have to be able to budget into your business model that you are going to be in a PTAB proceeding.
And from my perspective, it doesn't matter. I'm looking at the petition, I'm looking at the patent and the responses. Rarely do I recognize who the party names are.
Right, right. That makes sense. I'd say from our perspective, the Cisco perspective, most of our patent litigation dockets, the vast majority is actually still just being defendants in challenges against or from NPEs. Is that the same with you, Michelle?
Yeah.
So, how does that impact your case management strategy, given the inordinate amount of NPE cases that you're seeing, and how you use IPR? I think you mentioned it already with Julie about if they're going to settle for $20,000, it's probably not worth it to file an IPR. How does cost and everything else, fighting an NPE in litigation, kind of translate into your IPR practice?
So basically, we have now an additional tool to defend ourselves against NPEs, right? And it's a very effective tool. And while most of our docket is still NPE litigation, I would say that recently, maybe even over the course of the last year and a half, it's actually slowed down quite a bit. And I think that's in large part due to these new tools, right? The CBMs, IPRs. We've been able to get rid of a lot of our cases early on through that.
So you still find the IPR process pretty efficient, in other words, to dispose of NPE cases?
Yeah, very much so.
How about you, David? Well,
Yeah,
even take a step back.
Yeah.
What is your percentage of cases that you do that's on the petitioner side as opposed to patent owner side?
Yeah, so the majority of ours are on the petitioner side. Some, usually, again, it's going to be in competitor cases where it's on the patent owner side. However, one of the things that I am seeing, and I was quite surprised by this, is that we're seeing a lot more use of IPRs in the license negotiation stage than we did maybe 2 or 3 years ago. And largely this is because, we're dealing, for many of our clients, we're dealing with very large, well-funded assertion entities that are bringing big portfolios to bear, and there's a lot of money at stake. And one way to pressure test the portfolio, it's not likely that when someone brings 1,000 patents to you that you're going to do an IPR on all of them. I mean, that wouldn't make sense, and just the odds are that 1,000 patents every single one of them is not going to be invalid, right? But what this does do is it really does help with regard to setting the valuation and pressure testing some of these patents to see how strong they are, and using that as a mechanism to bring the negotiations to a better position.
Yeah, that's a very interesting point. And maybe that segues into costs and how maybe NPEs use that cost to factor in their settlement price. So how much does an IPR cost to file?
So I'm sure they vary widely, and again, they do vary widely on a case-by-case basis. But as a general rule of thumb, I would say you can, in terms of just getting a petition on file, can range from 65 to 110. Usually it's going to be more in the middle. If it's a patent with a lot more claims, it's going to be more on the high end and can even go above that. And then you have the filing fee and the expert. I would say from start to finish through oral hearing, you'll have costs that range in the $250 to $400 with gusts up to $600, and these are in terms of legal fees. And usually what derails things and creates more cost is when things get mired down with special issues, discovery issues and so forth.
Maybe we should hire Haynes and Boone to do our IPR. I think I'm going to say from start to finish, it's more like 500 to 600 is from what I in my experience. And that's just for one petition, but it's pretty rare that we file one petition. More likely than not, it's usually 2 petitions per patent. I've gone upwards of, well, many more than that, because there's a 60-page limit, right? And if there's a lot of claims, then you're going to have to, I've been burned before where, things were not as thoroughly analyzed as it should be because we thought they were kind of no-brainers and, certain it was obvious that this was there, but not to the PTAB board apparently. And so, we got partial institution on things like that. So my practice now is to file and just do as thorough a job as I possibly can so that, so it's worth filing. You're not just going to waste your money because partial institution for us is not a good, it seems like maybe a partial win, but it's actually a loss for us.
Yeah, there's such a premium on getting it right the first time because if you don't, that's, it's, the do-overs are not well received at the PTAB.
That's a great point. I think it was brought up in the earlier panel too about timing of when you file your IPR, when the clock starts in litigation. Any comments on that?
Yeah. So ideally, we always try and file our IPR petitions as soon as possible. In reality, that's not an easy task. For us, there's more often than not, 3 months can go by from service of the complaint to the time we respond to our answer. And that's just because of, extensions or, we have a foreign entity, so we get the 90 days. So once that, now you're 3 months in, well, we usually have to wait for infringement contentions to come out because, if you have a patent where there's hundreds of claims, you can't file an IPR because, that's very, very expensive, and at that point you might as well just stay in district court litigation. But so you end up having to wait until infringement contentions, and then I guess while you're doing that, you're looking for your experts, you're doing a prior art search, you're analyzing the likelihood of success of an IPR. I mean, there's so many different factors that go into play, and then like I said, it's basically a minimum of 2 IPRs per patent. So if you have hundreds of claims and multiple patents, and then you're trying to work with experts and look for prior art and then at the same time go back to your business unit and try and make a case for why you should be spending this much money on IPRs, that 1 year bar date actually sneaks up on you pretty quickly. And we need to make sure that we are drafting these things as thoroughly as possible because this is as important or more important, well, as important as a jury trial, right? Because this is your shot, and it's all about the first petition that you're filing. Because if you don't have something in a petition and you miss that, you're not going to be able to bring that up in an oral hearing, and so you're done at that point.
And from my perspective, I do encourage petitioners to file the petition as early as possible because when you get up next to that 1 year bar, there might be issues like real parties and interest, and there's no room to fix it, perhaps, if that's an issue. So we do encourage petitioners to file as soon as possible.
It's a real tension. It's a real problem, and sometimes we have cases where someone will say, look, it's very important that we get a stay in this case. We need to have this. We need you to file 3 petitions, and we need it done in 4 weeks. And very often that's just not reasonable. And again, the prior art develops as you do more searching and so forth, and then you need to get input in terms of the how the claims are being asserted against the products, and sometimes you're not even sure which claims are going to be in play because that isn't nailed down. So it's a real tension on doing it fast versus taking the time to make sure that you've covered all of your bases. And so again, I think part of it is in some scenarios there's an overemphasis on the need for a stay. because the idea is we'll get the case stayed and then maybe we can settle the case, or we can at least stop the costs on the litigation. But often, that can be done at the expense of making sure that everything was done the way you would want it if you had as much time as possible. So it's a balance, and then it usually gets worked out among the whole trial team on what to do.
Okay, no, thank you all for that really good discussion of that first segment. Again, that was kind of the look back, what people have been doing practically and otherwise in the past 4 years. Now we're going to hit some hot topics. The first two are definitely hot. They're getting a lot of traction, a lot of discussion, again, in policy circles and the like. And the first is multiple proceedings. And what we mean by that is under Section 325D, the board does have broad discretion to reject a petition in the case that there have been multiple proceedings, multiple petitions on the same patents where the art was or the arguments were previously presented. And so, Judge Elleroux, it's a broader question to you. How often do you see this occurring in your caseload?
So typically, a second or a subsequent challenge to a patent is assigned to the same panel that considered the first challenge. And even if it's assigned to a different panel, they're going to have access to that previous record. So they're going to know the full scope of the record, including the art that was asserted, as well as the arguments that were made. And we do have discretion to consider and deny a petition because the same or substantially the same art has been previously asserted in the office. It doesn't even have to have been asserted in front of the PTAB. So we do our best in our institution decisions, whether they be institution of trial or denials, to be very transparent and give good analysis for what we are doing. And we don't want that to be used as a roadmap by a petitioner to draft a subsequent petition that is better because of the lessons that we have provided in the first one. So typically, if it's the same or substantially the same art, particularly if it's the same petitioner, we're going to be closer to 325D. And maybe you move away from there if it is different art by different petitioner.
Okay, no, thank you for that. And I think, there's always a tension here, right? There's always two sides to that battle. On the one side, you've got the right of the petitioner to be heard. And on the second side, or the other side, you've got the right of the patent owner not to be harassed by multiple petitions, multiple arguments, and the like. So we'll cover both. I want to cover that first one first, which is the right of the petitioner to be heard. So the other panelists, in your practical experience, I know from Cisco's experience, we see a lot of MPE cases where we're not necessarily the first to be sued, right? We're the second or third wave of MPE litigations where previous petitions have already been filed. And so how do you deal with that from the petitioner's perspective when you are not necessarily the first in line to file, but you feel like you have or have a right to be heard?
So that's not an uncommon scenario. I think in that situation, we really have to take a close look at what was filed. And it really depends on timing. I mean, if the petition was not yet instituted, we may want to file our own, or, we have to consider whether to join it. We'll have 30 days of joining once the petition is instituted, right? Or if it's after that time frame, maybe we draft our own IPRs and try and consolidate. But it really depends on how strong we believe that first petition was, because I don't know if we get a chance to argue at oral hearing.
Well, it certainly depends. It depends on what the ultimate order is. If there's a joinder, in some cases you might not. But if you file one that's different, where you have different grounds, then more likely they won't be joined together, but they'll proceed in parallel if they're filed closely enough in time. And we'll see often we'll have cases where there'll be an oral hearing and there'll be two different petitioners and the patent owner, and one petitioner will go and do theirs, and then there'll be two proceedings. Usually they'll be in separate sessions that are back to back. But I think what it really comes down to in terms of the 325D discretion, which is, by the way, the the AIA, the rule development for the AIA was very good when they gave the PTAB that discretion. And I think initially there was a big fear that, oh, we're going to get deluged with all of these petitions and we only have, X number of judges and we need the ability to just have the discretion not to proceed. Now there's over 270 PTAB judges, so there's obviously the better ability to handle the workload. But still, multiple petitions, I think, is a big deal because I think it's over 30% of your workload involves multiple petitions. But I think on this balance of fairness between preventing harassment of the patent owner and allowing petitioners to be heard, really what we're looking at is how do you provide for procedural fairness, but at the same time, discouraging certain behavior, in particular by petitioners. And in cases that we've seen where you have multiple defendants in a case where patents have been asserted, there might be 8 to 10 parties that have been sued. My experience has been that the PTAB tends to weigh in favor of allowing different parties to file their own petition when they have been sued. It's much more difficult, however, in a situation where you have a first petition that's been filed, and then there's a piling on that happens against the patent owner. But in fairness, if it's all the parties that have been sued in the litigation, they are entitled to have their say. But usually what happens, and I think this still ends up being lessening the impact on the patent owner, is that it will often be a situation where you might have a first party that will file out of the chute immediately. It may be that the next party to file will file something different because they will have taken more time and perhaps done a more thorough job. Both of them will get instituted, but then you'll have the rest of the crowd. Usually at that point they will file Me Too petitions seeking joinder, and so it's very rare that you'll have a case where you'll see 8 different petitions, all completely different with different grounds. You usually will see, often you'll see a lead, and then sometimes if the other parties feel that that's sufficient, there'll be joinder onto that. And then I think what the office, the PTAB, does to streamline the procedure is, in most cases of joinder, the lead petitioner will have control, and unless they settle out, the proceeding will be handled primarily by that lead petitioner. So it creates some fairness there for the patent owner.
So we are aware of and sensitive to undue harassment by the patent owner of the patent owner, and repeat petition challenging the same claims raises that antenna. And we have broad discretion to deny a petition and decline institution, for example, where a patent owner is unfairly targeted by repeat petitions. We will consider whether and under what circumstances that the patent owner, it would be unfair for the patent owner to respond to a deluge of successive petitions. And in addition to 325D, as my panelist mentioned, we have the ability to join subsequent petitioners as a petitioner to that first case. And yes, we will let the petitioners decide among themselves who's going to be lead and how that should proceed. But we do have tools to streamline our proceedings, and in addition to joinder, we have the ability to consolidate proceedings, and it doesn't even have to be proceedings that are solely in front of the board. And even if a party doesn't request joinder or consolidation, perhaps the panel may even suggest it on its own.
It's like you read my outline. You answered my second question, which was, does the PTAB have the tools necessary to prevent harassment by multiple petitions?
I think so. Now that we've had some experience, we can tell when something's up. So when we do see that, we do have the discretion and the tools necessary to make sure that there is no undue harassment. But there is certainly the balance of interest between the petitioner and the patent owner, especially when there's multiple petitioners, and giving them their say.
Just in practice, though, I've seen a lot of the smaller patent owners, when they file against 1 or 2 or whatever parties, and someone puts their patent into an IPR, my experience is that they will not file again against other defendants because they're just trying to wait to see, one, if it gets instituted, and two, if it's been instituted, whether or not their patent is going to stay alive at the end of the day. And, if it does get instituted, there's a high likelihood that the future defendants will end up getting their case stayed. Maybe they'd have to agree to a full estoppel, but it's likely that they'll get the case stayed. And also there's Octane Fitness, right, with the new standard of attorney fees. That's something that they need to consider now too, because by institution, basically you're saying that there's a what's the words?
Reasonable likelihood of success on the merits.
Exactly.
Yeah. Mm-hmm. Yeah.
All right, great. Any other thoughts on that topic, multiple petitions?
Well, just one other, and that is again, the goal is to prevent the do-over and second bite at the apple. But there are cases where it's entirely appropriate to file a second petition, even when you're the same petitioner. And often, you'll have cases that are very, a lot of claims, very complex. There'll be an institution decision, and I've seen, the board actually say that there's nothing inherently wrong with the same petitioner filing a second petition, but there needs to be a good reason.
Okay, a good one to that point for that topic. The second hot issue is claim amendments. I think it was referenced but not really discussed in depth at the last panel, and that is the ability for patent owners to amend their claims during the IPR process. And the complaint that we hear in certain circles is that it's either rarely granted or really difficult to do. And I know, Judge Elleroy, you were on the panel for Aqua Products, so I'm not going to ask you about that in particular, but if you have any overarching thoughts about claim amendment processes in general,
sure,
that'd be very helpful to hear.
So patent owners are still filing motions to amend at about the same rate as they always have been. They filed between 50 and 60 motions to amend in every fiscal year except for fiscal year 2014, when patent owners filed 92 motions to amend. And so although we have heard that patent owners are not filing motions to amend because they think it's futile, that's not what we've been seeing. They filed motions to amend in 59 cases in this fiscal year, 2016, which is consistent with the filings from 2013 and 2015. Another point that I wanted to make is we have a claim amendment study that we've done that is available on our website, and it provides very detailed information on about 192 cases where motions to amend were filed. And of the motions to amend that were denied, the vast majority, I think 94 out of 116 as of the date of the PTAB study, were denied based on specific grounds of unpatentability. So to analogize with conventional prosecution as a comparison, they were denied for the same reason that they would have been denied in prosecution.
Yeah, so it's likely that in many of those cases there was a balance of trying to amend the claims but still preserve the infringement assertion in whatever the other proceeding might have been. So I think when you do see motions to amend, they're only done after careful consideration by the patent owner, and often maybe just don't go far enough in terms of actual, enough change to the claims. But in terms of the motion to amend study that Judge Elleroy mentioned, it's very good to look at that. That's fairly recent. It was in April of this year, and it's on the website, but it does show all of the different reasons why the motion was denied. If you want a very good example of a case where the patent owner was able to do it successfully and prevail, I would suggest looking at the Shinfu versus Tire Hanger case, which is IPR 2015-208. That was in April of this year, and that's a very good dialogue of going through exactly what how the patent owner did it correctly and was able to successfully amend the claims.
I also understand that the claim amendment process has evolved over time, right? Additional page limits. I mean, does anyone want to describe the changes to better accommodate claim amendments?
Well, I think it's been made to the extent you could argue there was any unfairness. I think it's about as fair as it can be in terms of having enough real estate in order to go ahead and make an effective motion, because the actual claim, the substitute claims themselves don't count towards the page limits, et cetera. I think probably the biggest event that I have seen lately has been this Federal Circuit case that came out August 30th of this year, which is Veritas versus VM Software. And in that case, this was the most controversial thing, I think, with regard to motions to amend. In order to have a grantable motion, in that case, the panel was requiring that the patent owner discuss each of the newly added features and discuss each of them and why they were separately known. And the Federal Circuit said that that was an unreasonable approach, and that really is all that was required was to discuss these new features in combination with the rest of the claim elements, similar to what would be the standard for non-obviousness under a KSR analysis. And I think with that change by the Federal Circuit, I think we're going to see perhaps maybe some more motions to amend being filed.
Now we can talk about in-ray aqua products, and I will excuse you or recuse you,
Thank you.
Judge Elleroux. So if you guys don't know, that is the case where it's actually up on bonk right now at the Federal Circuit. I think, let's see, oral arguments are December 9th, which is in a couple days. And one of the issues being brought there is who has the burden to either show patentability or to prove unpatentability during the IPR process. And so I think a lot has been said on both fronts. What are the other panelists' opinions on who should practically, policy-wise, have the burden of proof in that respect?
My vote is going to be for the patent owner.
Yes, I think that makes sense. Well, just for aqua products, what the issue is, the statute 316E basically says that the petitioner has the burden of proving a proposition of unpatentability. And so the argument is that that would apply to amendments to the claims because that's a proposition of unpatentability. So the petitioner has the burden of proving that. And as in contrast, there are other portions of the statute that talk about motions to amend or the ability to file a motion to amend. And the legal question is, what's the proper interpretation of the statute? Because clearly the rulemaking that was done by the office is it's clear that it is the patent owner that bears that burden. And so what I've looked at is I've looked at some of the briefing in this, and there's a amicus brief filed by the IPO, intellectual property owners, and then there is the intervener's brief filed by the agency. And there's different policy issues going on here. And the policies that are being proposed in favor of the patent owner, that it really ought to be the petitioner that bears the burden on amended claims. The policy reasons in the briefing really are going to the idea that and I'm using the words that are in the brief, it's important not to tilt the playing field against the patent owner to begin with, right? And so I think that's really the issue, is it's really coming down to this sense or feeling that that the motion to amend practice isn't as vibrant as what some feel that Congress had intended. I don't know that that's the case, because I think really this all comes down to how do you make this process more efficient? Because what we had with re-exam, I personally still have some re-exams that are in year 7. And I don't think that anyone wanted or intended that the AIA, the PTAB IPR process would go into that. The policy reasons on the other side in the government's brief go to the idea that allowing untested claims to issue, because let's say the petitioner decides they don't want to participate in resolving patentability of new claims, allowing untested claims to issue would represent a very sharp break in 100 years of policy in terms of having all claims examined. And the idea that there's no presumption of validity could possibly apply to unexamined claims. And so I think that's where this comes out, and it's going to be very interesting to see what the courts do with this issue.
Yeah, because I had that same question. What if the patent owner decided to amend the claims in a way that allowed the petitioner to say, actually, I don't infringe anymore, so I don't have skin in the game. I don't really need to move forward and challenge the amended claims or proposed amended claims. So what happens in that case?
Yeah, so that creates all kinds of problems, because then it really is, it's left up to the agency to decide whether to allow that. And I guess there could be situations where, the burden shifting aside, the PTAB will make its own decision on whether it thinks the claims are patentable or not. But also, even setting all this aside, you can still have director ordered reexamination, and but I don't think the intent of the process was to just let it skate through at the PTAB and then have the director decide to reexamine a patent. So I think the process needs to be right, and where the outcome needs to be right in terms of making sure that there is proper examination or consideration of patentability.
And just touching on that, once we are no longer in that infringement zone, we don't have any incentive to keep spending the money to make sure that those we don't care at that point, right? From a company standpoint.
Right. So that could lead to unintended consequences, and the whole purpose, I think, of the AIA was to provide more certainty and clarity in the patent law.
So I think we'll certainly be watching the Federal Circuit's hearing in a week and a half. So that'll be really interesting. So yet again, another hot topic. I'm going to move along now since we're right on schedule, but I'm going to skip to our one of the other hot topics that was mentioned, I think, by Judge Prost this morning, which is estoppel. And that's something that I remember even during the early drafting phases of the AIA, wondering how this was going to play out, right? So I think Judge Gilstrap said it this morning again, like, folks shouldn't get two bites at the apple, right? And that's really what the estoppel issue is really about, to prevent unfairly a company from getting two bites at the apple where they could have raised or reasonably could have raised art in the first instance. And so, 4 years have now gone by since the AIA has been passed, and I'm just wondering from the panelists, how big is estoppel an issue as you think about filing an RPR in the first place? I think particularly we already mentioned multiple petitions and trying to figure out whether or not you join an earlier petition. I think estoppel comes into play there. It may come into play in other instances as well. How does that play in? How big a decision or a factor is it when you decide whether or not to file an IPR?
We actually vet that decision. We take a lot of time to analyze that decision, whether or not to file this IPR, because, like I said earlier, number one, it's very expensive. Number two, you're not guaranteed to stay. If you file an IPR and not all your claims get instituted, then you're back in district court, and you're now having to, ideally you'd have different defenses that you can rely on other than what you had raised in the patent office. Because if you don't, and you're relying on the same art that the patent office has already deemed has already denied institution on, that decision might end up getting in front of the jury. It shouldn't, but I think there's a split in authority on that. And if a jury hears that the patent office didn't institute on certain claims that based on the same prior art, that kind of just is not a good situation for you. So ideally, we would have different defenses that we can rely on, and that whole 2 bites of the apple thing is, not ideal for us. We're not trying to get 2 bites of the apple. We would really just want to go forward with our strongest foot in the PTAB. I mean, I think that's preferred.
So the idea being that it's largely, you feel you're going to get a fair, largely a predictable result at the PTAB, maybe more predictable than a jury trial.
I think so. I think so. And because you have, 3 judges there who are technical judges who can maybe understand this very complex technology a lot, and know patent law, right?
Mm-hmm. I've always wondered whether, because the Shaw Industry case says that if there are multiple grounds and then some of them are not granted due to redundancy or for efficiency purposes, the Shaw Industries case says that those redundant or those grounds that were not instituted, there's no estoppel that applies to those. So I always wondered whether do parties ever take the strategy of, well, we have a rifle shot here, but let's throw in a couple of extra grounds and have them denied so that then we can save that for the district court, because clearly that's not something we reasonably could have raised because we tried and they told us they would not move forward. That's a much easier case than, well, I have a bunch of other references here and I'm not going to put them in the petition, and then later I'm going to try to argue that I should be able to use them. Well, you're going to face that you reasonably could have raised those because you didn't. So you're sort of in a situation where you potentially could hedge your bets a little bit by putting in too many grounds and then having some of them denied, and then being able to use that later. Anyway, I don't know whether that creates some kind of incentive. As a general rule, we tend not to do that in the petitions, because the last thing you want is in your petition, when you have multiple grounds, you don't want to be in a situation where your arguably weakest ground ends up being the one that the PTAB goes forward on. So try to be very careful in what we put in the petition. I think a clear case, though, where the estoppel does not apply is in the case where you have an on-sale bar or some other type of prior art that then you can later use, maybe in combination with the art that was in the proceeding.
Right. That was going to be a follow-up question, which is from the practitioner's point of view, how you select prior art that goes into the IPR and how you select art that might be brought in front of the district court. And I think the on-sale bar is a perfect example of that, right?
We also like to look for prior art products, because that's not something that you could put into an IPR.
And that's usually better. That's a more jury-friendly type prior art anyway. Right.
Okay, that was perfect. We're right on time for our third and final segment, and that is kind of looking into the future and trying to figure out where the PTAB practice is going and any developing trends. And that also leads us to our second exciting poll question of the day, and that is which type of petitioner fares better at final written decision? The earlier question was what kind of patent owner fares better. This is who on the petitioner side fares better. A, operating companies, B, defensive aggregators, or C, no discernible difference. And I'll just add a little bit of flavor. So B, what I mean by defensive aggregators are folks like RPX, folks like Unified Patents, who do a lot of different things, but one of the things they may do is go out and try to invalidate NPE patents for its members, not necessarily and probably not at the control or a request of the members, but they go out and do these things. Of those two types of entities who file petitions, who does better at final written decision? So who thinks operating companies do better? All right, got a few people, Michelle included. B, defensive aggregators. All right, I'm seeing some defensive aggregators raise their hands. Very good. And then C, no discernible difference. All right, I'd say it's a mixed bag here. So let's see. Let's see what the right answer is here. Okay. Well, it's B. Well, before Michelle kicks me under the table, the stats here again by RPX. I do want to point out that companies like Samsung, for example, have a lot bigger data set here, right? So Samsung has 64 that have been finally adjudicated as opposed to unified patents or RPX. Again, we're just talking about final written decisions here, so it's a much smaller subset. But RPX and unified patents up to date have had a pretty good track record when it comes to final written decision outcomes. I'd say operating companies obviously file a lot more, and some of them are doing very well as well. And so this is just the top most successful petitioners at final written decision. But it gives us a flavor of what's going on in the industry, particularly in the tech industry, where we do see companies like RPX, like Unified Patents, filing a number of IPRs to invalidate questionable patents in the hands of NPEs or PAEs. And so the broader question to this panel is, do you see this trend as well? In other words, not just traditional operating companies filing petitions based on patents that were asserted against them initially in district court, but the more onset of these defensive aggregators who are doing this type of IPR filings on their own.
Well, I think it's a good thing, because the whole idea that there can be more people paying attention to a patent and to put it in the crucible and test it, that's good. And I think that's largely dictated by the marketplace. That's obviously not going to happen on patents where someone doesn't feel that it's financially justifiable to spend the money. So I think that this is the idea of what the AIA intended, is the ability of any member of the public to challenge a patent.
And again, from my perspective, I'm just looking at the petition and the patent and the arguments that are made, regardless of who's making them.
Just on that note, I had a very good outcome just this week on a case that I was handling, where RPX stepped in and filed 3 IPR petitions. And whoever they used was really good, because they found a unique abandonment issue where the parent PCT application was never co-pending with the U.S. child application. And I think that was just kind of like a filing error, really. And that parent ended up becoming 102 prior art to the child. And so the defendants in that case took the arguments that were raised in the IPR and went to the patent owner and said, what is your response to this issue? Because it kind of seems like you don't have a valid patent. And the patent owner said that we'll take a look at it, we'll go back and let you know next week what happens. And the following week, which was I think on Monday, they voluntarily dismissed the case with prejudice, and this was before any of the defendants even had to file an answer. So this is something that had been filed the case was filed in June, and they gave us a very long response date for whatever reason. It was like 100 days to respond, and so I think they were hoping to get a quick settlement out of it, but they ended up with not getting anything. So I'm a big fan of RPX now.
Generally, I mean, even to you, Judge Alaru, do you see a trend where IPR filings are going to increase, decrease, steady state from here on out?
I think based on the last 2 fiscal years, it seems like we've reached steady state. Like I said, there may have been some peaks and valleys last year that we haven't seen this year. They've been more steady from month to month, but I think we have reached a steady state.
Any other last thoughts on trends, what we're seeing in the field from the practitioner's point of view on where PTAB practice is going?
I think it's stabilizing quite well, and I think it's proving to be quite effective. I think having agency review is going to be, it's now going to be the new norm, is to have this two-track approach to resolving patent assertions. I think we're going to continue to see more appellate review, largely going to procedural fairness and making sure that that it's a balanced process for both the patent owner and the petitioner.
I think that with anything, there could be improvements, but I think overall, in general, the goal of a quicker and more efficient way to challenge patents has been met.
Yeah, and I think that's, I think we've seen that the PTAB has, they got a ton of cases, but they've also, evolved as well in terms of practice to make sure from the claim amendment perspective that things move along more fairly. I think in other topics that we've covered today about multiple petitions, we've seen the same thing. Is there a thought that we would need legislative reform to fix any of these perceived issues with the PTAB practice, or do we think the PTAB has the tools already in hand to continually improve and make the process more efficient and fair?
Well, my view is that that the process is shaking out, and that there are some adjustments being made here and there, but fundamentally, I think it's what Congress had intended.
And we're always eager to hear from the public, and that's why we do have these outreach events, and that's why we do go out and meet with the public, and we do have rulemaking authority to fix anything that we may think needs fixing. So I think we do have the tools as well.
I'd actually like for the institution decisions to be reviewable, but that's just me.
Great. So we've left 5 minutes for Q&A. We have exactly 5 or 6 minutes. I also hear China tinkling in the background for lunch. So I'll leave it up to the audience. If you have any questions, feel free to ask the panel. Well, hearing none, I want to thank the panel profusely. This has been a really interesting discussion, and I'm very humbled and honored to be sitting here with you guys. And thank you for the audience for paying attention and voting. Appreciate it. Thank you.